Today I'm basically referring to a few pieces of research that fed into the ALRC evaluation of the the 2006 family law reforms. We were commissioned to do that research by the Attorney General's Department and FACSIA. And so I'll be referring to that data plus the new developments in the Family Law Act, the legislation that's been a response to the evaluation and other pieces of work, and also referring to the longitudinal study of separated families, which has had a subsequent wave since the evaluation. So basically I'm presenting my views today as a researcher. I'm not an official mouthpiece for the government. Today I'll be just running you through a summary of the recent legislative changes to the Family Law Act. I think Zoe is probably going to talk in more depth about the changes, but I'm just going to give you an overview to provide a context for the discussion of the data that follow. I'll then be talking about the empirical evidence about the prevalence of family violence and safety concerns among separated families, and then discussing the way that the families that are affected by these concerns make their way through the system and the findings about where they go and what happens to them. So basically, we have a new raft of amendments to the Family Law Act, to Part 7 of the Family Law Act, which is the part of the Act that governs the resolution of post-separation parenting matters, so matters to do with children. The Family Law Legislation Amendment, Family Violence and Other Matters Act was brought into force in 2012, and the main substantive provisions have come into effect fairly recently on June 7, 2012. Basically, that piece of legislation responds to the findings of the ALRC evaluation of the 2006 family law reforms, the Family Court Violence Review by Professor Richard Chisholm, which was a review that analysed the way that the family courts handle matters involving family violence and child safety concerns. I think you'll hear more about that from Zoe. And also a report by the Family Law Council on improving responses to family violence in the family law system. So there was a very significant evidence base that underlies the latest raft of reforms. I just want to refer to a few significant features of the new legislation. We have a much broader definition of family violence in this new raft of legislation. The old legislation had a definition of family violence that looked pretty similar to the common law definition of assault. So it referred to behaviour that, caused a person to fear for their behaviour, but it didn't explicitly refer to any of the types of conduct that for many years now in the state family violence legislation frameworks are recognised to be elements of conduct amounting to family violence. So those things are things like denial of access to physical resources, to financial resources, things like stalking, things like verbal abuse, things like denying access to culture and social activities and so forth. So moving away from a fairly narrow definition that looks like common law assault to a much wider definition that recognises the knowledge that we have developed over the past decades about the kinds of behaviours that amount to family violence that aren't just physical. Importantly, this new legislation also refers to the exposure of children, and that is recognised and defined, and so there's quite a definition around that that I won't go into today, but it's there in the Act. We also have a new definition of child abuse in the Act. I'll just give you a moment to absorb those words. Previously, the Act just picked up the state and territory definitions, but now it has its own definition, which is fairly wide, and again we have exposure to family violence recognised and acknowledged. And basically our findings from the 2006 family law reforms indicated that where parents reported a history of physical or emotional abuse, something like 60 to 70% of them also reported that the children were exposed to this behaviour. Okay, so another critical aspect of the new legislation is the resolution of what's been referred to as a fundamental tension in the previous Part 7. This tension revolved around the principles in the Act that were said to be the primary considerations in the best interests determination that judges need to undertake when they're considering a parenting matter. And so we had two provisions. We had a provision revolving around the child's right to meaningful involvement with both parents, meaning a meaningful relationship with both parents after separation. And we also had a provision that referred to the need for them to be protected from harm. And in the previous legislation, there was no clear guidance in the Act about how these two tensions should be resolved in any particular matter. It was a matter of discretion and a matter of how the particular case was litigated. And this was referred to by Professor Richard Chisholm as one of the fundamental complications in this legislation, resulting in a real lack of clarity. The new raft of amendments specify quite explicitly that where those two principles conflict, meaningful relationship and protection from harm, that greater weight should be given to protection from harm. So there's very clear legislation that tells us now that the thing that really is most important is to protect children from harm. Also significantly, advisors' obligations have changed in these new provisions. Advisors are people such as counsellors, lawyers, people in the family relationships sector who give advice to parents when they're separating. And under the previous legislation, they had an obligation to advise parents to enter into a parenting plan and to consider equal or substantial and significant time. Those obligations have now changed, and basically the things that advisors are obliged to tell parents about now concern the fact that the children's best interests are the preeminent consideration in making parenting arrangements, and that the best interests amount to an arrangement that allows a child to have a meaningful relationship and protects them from harm. And again, it's indicated in the legislation that where these conflict, greater weight should be given to protection from harm. So we see the obligation on judicial officers mirrored in the advice-giving obligations that are imposed on advisors. There are also some provisions that are intended to encourage disclosure of concerns around child safety. So there are obligations on parties and lawyers to inform courts of arrangements under child welfare law, and whether there have been investigations, whether there are notifications and so forth. And so this is to encourage evidence of concern around child safety to be brought before the court. I just also want to refer quickly, and perhaps Zoe might talk about this more, about the removal of some provisions in the old legislation that were seen to create pressures that would inhibit people from raising concerns around family violence and child abuse. And two of those important provisions are Section 117AB, which was the costs order for knowingly making a false statement in proceedings. This provision required courts to make a costs order where a party was found to have knowingly made a false statement in proceedings, and that provision has been repealed, so it's no longer in the legislation. The other important provision that has been removed from the legislation is the provision that requires the court to consider the extent to which one party has facilitated the child's relationship with the other party, so the so-called friendly parent provision. That's no longer explicitly referred to in the legislation. So those couple of provisions that were seen in practice to inhibit people from raising concerns about family violence and child abuse are no longer in the legislation. So I just want to refer briefly to some of the findings from the evaluation that have underpinned, together with other pieces of evidence, the recent changes. I'm just acknowledging my colleagues at the Institute, Leisha Chu, Ruth Weston, and the APES evaluation of the 2006 Family Law Reforms team. That was a very big team comprising 22 people. So the data I'm telling you about today represents the efforts of a very big team of researchers. It's not just my research, it was very much a piece of research that many, many people had input into. So I'm going to talk about the evidence in relation to the prevalence of family violence before and after separation, safety concerns, the prevalence, duration and nature of safety concerns. I'm going to talk about the kinds of pathways that parents affected by violence and safety concerns take through the family law system. And I'm going to talk about the evidence in relation to the kinds of care arrangements that families affected by family violence and safety concerns have. Just briefly, I want to just highlight through this slide the fact that our findings indicate that a history of family violence, defined broadly, meaning physical hurt and a range of non-physical kinds of abuse, including denial to financial resources, insults intended to shame, belittle and humiliate and so forth. This kind of history is actually more common than not among separated families. So you'll see that 35% of mothers don't report any such history, and 47% of fathers don't report any such history, meaning that actually majorities of parents, and in mother's case significant majorities of parents, report such a history. I also just want to point out in relation to these data that they're fairly bald prevalence figures. They don't allow us to understand some of the more complex dynamics around family violence, including those dynamics around acts that might be defensive or aggressive. We don't understand much about chronicity, severity or impact. Okay, so we have very broad understanding of prevalence, but our understanding of those other more complex issues will actually be developed with subsequent pieces of research that I'll refer to imminently. I just want to basically show you the kinds of abuse that are most prevalent among mothers and fathers. This is data from Wave 1 and Wave 2 of the longitudinal study of separated families. So that taps the experience of 10,000 separated families in 2 waves. So it's a near nationally representative sample. So that you can see that insults are very common, and you can see that, you know, damaging and destroying property is very common. You can see that some of the subtypes diminish after separation, which is when we collected data some 2 years to 2.5 years after separation. Some types diminish, but basically there is still, if you look at the aggregate figure at the end, there is still a significant amount of either physical and mostly emotional abuse, mostly non-physical abuse perpetrated in that post-separation phase. I won't talk in detail to that slide, but it's there. I'm very aware that we don't have a lot of time. I also just want to refer to this slide, and it tells us that post-separation there is still a lot of abuse perpetrated, although physical abuse diminishes significantly, but those other non-physical types of abuse continue to occur. I want to talk a little bit about safety concerns, and this is a fairly critical issue. In our first wave of the LSSF Wave 1, we found that around a fifth of parents reported ongoing concerns for the safety of themselves or their child or both after separation as a result of ongoing contact with the other parent. And basically from Wave 2 of the LSSF study, we understand that that figure of 1/5 is still relevant to that cohort. But what we find is that there's around about 7% of parents for whom the safety concerns disappear. There's a core group of around 10% whose safety concerns are maintained throughout both waves. And then there's another group of 7, 8, 9% for whom safety concerns newly arise. So we understand in both waves that there's around 20% of parents who have safety concerns. They diminish over time for around a half. They arise newly for around a half, and there's a core group of around 10% for whom they are sustained. So that gives us some indication of the dynamics around those issues. Just referring very briefly to the kinds of behaviour that give rise to these safety concerns. We can see that emotional abuse and anger issues are the most common source. Mental health issues are also quite common. Violent and dangerous behaviour is fairly common. Alcohol and substance abuse is fairly common as well. And then we have a smaller subset whose concerns are related to gambling habits. I just want to refer to this slide to demonstrate the point that when the legislation in 2006 was introduced, there was kind of an idea that people who had a history of violence wouldn't use family dispute resolution. Family dispute resolution is a mediation process where you attempt to resolve your parenting dispute through discussions assisted by a practitioner called a family dispute resolution practitioner. There was stronger legislative encouragement in the 2006 reforms for parents to use these mechanisms, but family violence was an exception, okay? You did not have to use family dispute resolution if you had a history of family violence. But in practice, things evolved very differently on the ground, and our findings show that many people affected by family violence and safety concerns do use family dispute resolution, and these data demonstrate that they do arrive at agreements through that forum. So you'll see that 48% of parents who did not report violence came out of family dispute resolution with an agreement. And I should say it was around, if you apply a broad definition, around 7 to 10% of the sample used family dispute resolution. If you apply a narrow definition, it's 7 to 10. If you apply a broader definition, it's a much higher proportion of around 30%. So if we just compare, for example, the parents where no violence was reported, 48% used family dispute resolution and came out with an agreement. If we look at the physical hurt cohort, 36 used family dispute resolution and came out with an agreement, 36%, and 38% reporting emotional abuse alone used family dispute resolution and came out with an agreement. So that very clearly shows us that matters involving family violence and safety concerns are dealt with in family dispute resolution, which was not something that was originally contemplated when the 2006 family law reforms were introduced. I just want to highlight that the Wave 2 results are fairly, they also continue to confirm that this continues to be a feature of the family dispute resolution climate in Wave 2 of our parents' experiences. We can see that they are still using family dispute resolution. These data are for the whole cohort, not the violence-affected cohort. Again, I just want to highlight the fact that our Wave 2 data shows very much that people move around the system. So this slide depicts the parents who had an agreement in Wave 1 and were renegotiating their agreement in Wave 2 and the pathways that they were using. So, for example, you can see that with this slide, that particular figure is an interesting one because it tells us that of the parents who reached an agreement in Wave 1 and were revising or redeveloping arrangements in Wave 2, 26%, so more than a quarter, were then going on to court. So there's a lot of movement between the different parts of the system in these data. That's what we're learning, that people don't just make an agreement and move on. A lot do that, actually, I should say. But there is a cohort who just, they move around. They make an agreement, they need to revise it, things change, and they'll move to another part of the system. So from FDR to lawyers and courts, for example. I just want to highlight the patterns in care arrangements. You'll see that care arrangements and safety concerns. So the fifth of the parents that had safety concerns, I just want to highlight that 16 to 20% of those parents with safety concerns also reported having shared care arrangements. And the figure overall for the whole sample of 10,000 separated parents, around 16% had shared care. So among the group with safety concerns, it was as many who had shared care, if not more, than the parents who were not affected by safety concerns. And again, this slide makes a similar point. Okay, so 16% of children across the 10,000 strong longitudinal study of separated families had shared care arrangements. Between 16 and 25% of children whose parents reported physical hurt had shared care arrangements, and between 16 and 20% of children whose parents reported ongoing safety concerns. Now, this was not intended in the legislation, and if you look at the way the legislation is configured, the presumption of equal shared responsibility is not applicable to families where there is a history, reasonable grounds to believe there has been a history of family violence or ongoing safety concerns. So that, that's an interesting and somewhat concerning figure. So basically the implications of these findings is that we need less inappropriate use of family debt dispute resolution. We need more reliance on the exceptions to Section 61I, Section 60I, which is the provision that states that you need to attempt family dispute resolution, but if there are safety concerns or a history of family violence, you don't. Okay, you can go to court, you can go to a lawyer. We need more effective screening and assessment practices to ascertain who these families are that shouldn't use these mechanisms. And we need less inappropriate referrals to family dispute resolution. We need fewer inappropriate care arrangements, better mechanisms for screening, assessment and facilitating disclosure across the system, including to lawyers and courts, better avenues for interprofessional communication. With all of these parents moving from one part of the system to the other, there needs to be some way for communication to occur between those parts of the system so that a thorough and holistic picture of these families in any particular case can be developed. And we also need better understanding among professionals of circumstances in which shared care is inappropriate. So just to summarise, the evidence is clear that matters potentially involving risks to children are dealt with across the family law system. We found that most parents actually resolve their matters by themselves, between themselves through discussions. It was actually the parents who used formal avenues, such as family dispute resolution, lawyers and courts, to resolve their matters. They were the ones that were more likely to have a history of family violence and concerns about child safety. These new provisions that I discussed at the outset of the presentation provide clearer guidance about how such concerns should be dealt with, and they provide further imperatives for refining practice in this area. So there really needs to be a change on the ground in the way that practitioners screen and assess for family violence and the consequences that follow. I just want to refer extremely briefly to some further pieces of research that we're doing that will further assist to enhance our understanding of these issues. We've been funded by the Attorney General's Department to do another wave of the longitudinal study of separated families, so we'll understand more about those families further into their separation trajectory. We're also in the field at the moment doing a survey of recently separated parents. That will examine the experiences of families who separated 2 years ago, so they will have been interacting in their early separation period with services and the family law system last year, so that's a pre-reform, tapping pre-reform experiences. And we're also doing a study on independent children's lawyers and how they operate in the family law system. Just another thing I'll refer to, because I know that services in Queensland are involved in this. We've evaluated the Coordinated Family Dispute Resolution pilot program, which was designed it was a model designed by Brisbane Women's Legal Service for family dispute resolution where there's been a history of family violence. We're working on that report and it will be provided to AGD later this year and hopefully publicly released sometime next year. So there are many developments going on to address the issues that have been highlighted by these data. Thank you for listening.
Thank you very much, Rowan. That was perfectly timed. Now we've got 5 minutes just for questions that might clarify the content of Ray's presentation, because as you know there will be a forum after all of the speakers have made their presentations, and there'll be the opportunity for discussion and dialogue with the presenters in the forum. But if there are any questions of clarification, there's an opportunity to do that now. And whilst you're thinking of your question, could I ask people again if you would please turn off your mobile phone? Thank you. Any questions for Ray? Rachel? Hi.
Hi, Heather. Ray, just in regards to the data that was collected, with women I've spoken to, when you talked about them resolving this through the family law practitioners, a lot of women have stated that they're not comfortable doing that dispute resolution service where there's been domestic violence. Even if the physical has stopped, there's still the intimidation. But they've felt pressure due to financial restrictions of not wanting to go to court, can't afford a lawyer, can't access legal aid. and also because of the intimidation by the perpetrator, that they feel they need to be there. And also they've had, many women reported from, when you talk about the advisors,
yes,
the information they've been received, they've felt pressured by those people as well, that, oh, you're better off doing it this way than going to court.
Yeah.
So was all that sort of information sort of allowed to be, I guess, disclosed in the survey when you're collecting that?
We certainly did collect data. I mean, there were many data collections. We did collect data about satisfaction with the process in the LSSF W1, and I should say that actually most parents reported that they were satisfied with the process, but we also did do other pieces of data collection, including qualitative data collections with professionals where those kinds of concerns were raised and reported. And there was also a survey of clients of FRSP, so Family Relationship Services Program, funded programs. And that survey actually did highlight that something like 70% of parents who accessed services were fearful of the partners that they accessed the services about, and around 10%, so 35% of the ones who reported being fearful did also report that the concerns weren't addressed at the service. And now we don't know whether the concerns were disclosed or not, but that's certainly, you know, an important piece of information that people have considered and taken into account. So those kinds of issues were captured, and I think the evaluation highlights the fact that there are many people who can self-manage quite effectively and they're okay. There are many people who use services and they're fairly happy and okay as well. But there is a subsample, there's quite a significant subsample, that have complex issues and they're not okay, and their service experience may not be very good or very effective. And I think these are the kinds of findings that have led to things like the development of the Coordinated Family Dispute Resolution pilot.
Good morning, everyone. I'm very pleased to be here today and to continue the discussion which, as Heather says, she and I have both been involved in, as have many people in this audience for many years, maybe not everyone for 30 years, but there's probably people here who have been. Some of what I'm going to cover is similar to what Ray covered, but I suppose that I have the joy of speaking from the perspective of academia and from, I guess, building on all my years of working at the Women's Legal Service, so that I intend to try to take a critical view and analyse in some ways how I think some of these different provisions in both of the pieces of legislation might actually play out. And I suppose that that is something that we started to do at Women's Legal Service, try to anticipate in advance how some of these changes to the law might work, so that we could make submissions about proposed areas of law reform to try to identify in advance what might go wrong and sound a warning. And this is really why I've called it interactions and complete misses, because I think that in respect of these two pieces of legislation, there are some very good interactions, but there's times when they just go like that. And that is going to create some problems. Now, part of the reason, of course, why that happens is to understand that really these two pieces of legislation come from a very different place. The Domestic Violence Act is, of course, state-based. It was born and bred in Queensland, whereas the Family Law Act reforms on family violence are from the federal government. The DV Act will be dealt with in the Magistrates Court, and on the whole, the family law reforms will play out in the Family Court and the Federal Magistrates Court. They can be in the State Magistrates Court, of course, jurisdictionally, but that's fairly rare. The key service providers for the DV Act are the police, the DV sector, lawyers obviously as well, but not as prevalent in that field. Whereas in family law, there's lawyers, family relationship centres and other forms of family dispute resolution, counsellors, consultants. So you've got different professionals, and that's one of the reasons why I think we sometimes do see these misses, because there is still a bit of a silo, family law and domestic violence, apart from all the other silos that we all know about. Importantly, the domestic violence reforms have reformed the entire piece of legislation that we used to have. It's a complete overhaul of the legislation. The Family Law Act is an amendment act. It's little bits, little pieces that got changed in a very big act, which is a very different thing to actually do. The Domestic Violence Act is about family violence. The Family Law Act is about separating families. It covers everything, property settlements, all kinds of things. Family violence is a tiny piece of that legislation. So the DV Act has its very own policy objectives clearly identified. It has preamble, objectives and principles all there in the Act. Whereas the reforms that were brought in terms of the Family Law Act have no purpose clause, no preamble, no specific objects, because it's an amendment act to a big act that already has those things built into it. And I'm not actually going to go through the detail of that here, but some of those principles are about maintaining marriage as the fundamental institution of humankind and things like that, except apparently if you're gay or lesbian or anything like that, because not wearing can undo parenting in Queensland. I've thought about that one for a while. Okay, so the domestic violence legislation, you know, its genesis appears to really be in that document for our sons and our daughters, brought out in 2009, and I'm sure that many of you, saw that legislation, saw that document. So this was a Queensland Government initiative to overhaul all kinds of things in relation to domestic violence, and one part of it was to completely review the Domestic Violence Act. They had 5 different areas of action that is noted in for our sons and our daughters, and I must say, I think extremely badly named 5th area of action, system planning and coordination. You'd rush to be involved in that group, wouldn't you? That is the group that actually has looked at the death review panel and at the review of the domestic violence legislation. I don't know why it didn't get called something like legal system reform or something like that, rather than, that sounds more like, something you get one of the IT geeks in to have a look at. But anyway, that's what they called it. And this is, so, that is where that review then of the Act fits into that one area of action under this whole of government initiative looking at family violence. And you see that very broad, emotive, vision statement. All people, regardless of gender, race, ethnicity, sexual orientation or personal circumstances, are safe and live free from domestic violence and family violence in Queensland. A very powerful statement from government under which everything then flows, whether everything is right or not, but there you see that very big picture statement. So then the second stage of the reforms here in Queensland are then moving into the detail of the actual consultation paper on the review of the Act. And there what you see they're drawing on, and this is where I want to kind of point out to you that at first really the Family Law Act and the domestic violence legislation are coming in a way from different places. The Queensland Government has decided to review all our family violence stuff, and the review of the domestic violence legislation is one part of that. By the time they put out their consultation paper in March 2010, as opposed to back in 2009, even more things are starting to happen. The ALRC is doing its work. The National Council to Reduce Violence Against Women and Their Children have put out their Time for Action report. If I might get some of these names a little bit wrong, but you know what I'm saying. So by the time that review starts to come out, there's more things that can be fed into what's going on in the state domestic violence legislation. And in that consultation paper, they talk about the scope of the review being, though, still to develop legislation to support our own state idea for our sons and our daughters. And that is what is being seen as a key to that review. Also to bring a contemporary understanding of domestic and family violence into the legislation. And a lot of that, I think, comes back to issues around the definition that did exist in our Act, but also a range of other issues. And this idea of efficiency and effectiveness in its intersection with other legislation, which was also what the ALRC had to look at in its more completely overall review. So in terms then of what's happening kind of simultaneously at the federal level, you've got the Family Law Act, family violence amendments kind of are starting to also emerge. So if you read the documentation around the bill, I'm sure everyone knows, but just to make it clear, you know, the kind of order that things tends to happen in legislative reform process is often the government might first of all put out a consultation paper that's fairly general and may or may not actually have kind of section numbers in it. Then you get a bill, which is the kind of first attempt at actually saying what they're going to do. Sometimes governments send out a bill that doesn't actually go through Parliament, that will be called an exposure draft, but that actually starts to give you the words that are intended, and then that bill eventually becomes the Act. So at the point of the bill, which was already a couple of stages along, what they say in the material with that is that this legislation is responding to the evaluation that Ray was talking about, the family violence review that Professor Chisholm had engaged in, and the Family Law Council report on family violence. And there's a couple of other reports of the Family Law Council I saw out there on the desk for you to pick up. The explanatory memorandum that went with the bill also mentioned a number of other reports. But what is interesting is that it made no mention of the work of the Australian Law Reform Commission, and I'm sure many of you were involved in that process. No mention of it is made at the time that that bill comes through. And that's the Australian Law Reform Commission, not the Queensland Law Reform Commission. So it's a federal thing, and here's the federal government spending lots of money on the ALRC, and they don't manage to mention it, which is really interesting. And I thought maybe I'd gone mad, and maybe it was mentioned and I missed it, until I read the Senate report on the bill, so that when the Australian Senate reviewed the bill, they made the comment that the ALRC report wasn't mentioned either. And nor was the National Plan, which became the next stage of what the National Council to Reduce Violence Against Women and Their Children, they put out their Time for Action report, and that's kind of moved along without going through all the detail to a point where it's been endorsed by COAG and has become the National Plan. But in fact, probably at about this time, they would have been very tightly timed with each other, but there's no mention of it at all in the explanatory memorandum. So the point that I'm making is that we get all mixed up with what we're trying to do. The federal government and the state government both say that they're going to do these things and they're going to link everything, and that this is all about efficiency and effectiveness and interactions and all these things, and then they completely don't even look at what themselves are doing and miss half the things they should have talked about, and they certainly have no idea about what the others are doing and don't talk about them at all. I must say that I do take the view that we would not have seen specific reform to the Family Law Act around family violence provisions, although these other things are going on at federal level. I don't believe that anything would have happened this quickly to already be amended. You all know how much work went into those 2006 reforms and how much angst and how much politics. We wouldn't have just picked out the family violence bits to amend again. I mean, there was so much said about that at the time, and they went ahead no matter what with their proposed changes in 2006. And I do think that it was the community outrage that occurred after the tragic death of Darcy Freeman when she was thrown off the Westgate Bridge in Melbourne. That sparked a different level of community concern, and it was that led to Richard Chisholm's report. And I think that's what drove it to happen when it did. I'm not saying that some of these things mightn't have happened. And here we see what the Herald Sun had to say about Darcy Freeman. The murder of Darcy Freeman by her father following a child custody dispute is inexcusable, but the legal system should take some of the blame. An advocate for single fathers says, and for those of you who've been in the sector for a long time, guess who I'll be quoting now? Barry Williams, president and founder. And look, you know, the man has worked tirelessly, I have to say, and I don't disagree with everything he says. But sometimes what he says brings its difficulties. And I do think that there is a problem blaming the legal system for Darcy Freeman's death. It's not the legal system who threw her off the bridge, it's her father, and we all know that. But I do think that that kind of public outrage that occurred then really partly then sparked the specific reforms that we've ended up seeing. So I'm now going back to compare the policy things. And what I want to show you is how different things are. How long have I got about still halfway? Is that right?
You're right, yeah, you're about halfway.
I'm not, of course.
Yes, you are. Don't worry.
I want to make this clear to you. The domestic violence legislation in Queensland, the policy is all about domestic violence. And I've already pointed out these, you know, the preamble or whatever. These create powerful legislative devices. And these words in the explanatory memorandum are strong words about, you know, human rights, human and economic costs, emotional trauma, etc. The language of the DV Act is very strong in the preamble. Living free from violence is a human right and fundamental social value. You know, the preamble doesn't count as law. It's a context, but it doesn't get, it's not actually part of the Act, if I've got that exactly right. But it's these are very powerful contextual statements, very, very powerful words that are said here. That's just two of the clauses in the preamble. The Act has a set of objects which are about maximising safety, preventing and reducing domestic violence and holding perpetrators accountable. And there's this, one of the key principles, I think, is this idea of the need to identify the person most in need of protection, which brings in the idea of the primary aggressor. Now, can I say, I think there's going to be a lot of complexity in how that plays out, and I'm not going to be able to talk about this here in what I'm doing at the moment. I think it's an incredibly important aspect of the new legislation, but a bit scary, because I think that we are bringing, and I'll come back to this a bit more, social science concepts into legislation and allowing lawyers to be the interpreters and assessors of those social science ideas. But we'll come back to that. The Domestic Violence Act, on the other hand, as I say, no specific anything about anything because it's an Amendment Act. And even if you read the explanatory memorandum, it's much blander kind of language. Look at that. The safety of children is of critical importance and the government takes the issue of addressing. It's not emotive, it's not exciting, it's not like that other language, I don't think. And as Ray mentioned, read the explanatory memorandum of the family law stuff, and here we see that tension. What do they say? These amendments address issues of significant community concern by strengthening the role of family courts, advisors and parents in preventing harm to children while continuing to support the concepts of shared parental responsibility and shared care. So that tension sits right there in the explanatory memorandum. We're going to try and fix up the family violence stuff, but so long as we still hold on to our deeply held principles of these other areas. Now, Ray's already pointed you to that new provision that when you look at the primary considerations now, it is primary consideration, the second one, that is to be given greater weight. I do think that that could prove to be one of the most important and useful amendments to the Family Law Act, and if that plays out like it should, that could be extremely helpful. But there's probably some complexity. As Ray said, so I don't need to really go through these repeals were incredibly important. The friendly parent provision I've got at the first one there, and the costs orders one, and I'm sure that many of you are familiar with those. Can I say, let me say the political thing about this. What is problematic about the fact that those two pieces got reformed now is that if the government had listened to women's groups, to domestic violence advocates, and for that matter even to some esteemed bodies, I think some of the law societies and whatever, their submissions in the beginning, these two sections should never have gone in the first place. So although I'm very happy that they're coming out now, this would be, in the 30 years that I've worked in this area, the 30th time that stuff that I, along with all, people, I don't mean I'm special here, but that all of us argued don't put them in. And then they go in and then we spend the next 5 years collecting data as to why they shouldn't be there. And then we all make submissions. At least now with computers it's all cut and paste. Oh, the submission I did in 2003 is still relevant because they went ahead and did all the things that I said not to. So great, I'll just cut and paste and say once again, don't do them. So they did come out. But they just should never have gone there, and that's the problem. And it shows the power of the father's rights lobby, really, is what that shows. So where am I up to? I've completely lost my place. Here we go. I'm not going to go through this one in detail, so I want to get on to some other things in the diminishing time I have. It is important that you do all know that the section in the Family Law Act that says that that the family court must take into account, or when it's making a parenting order, it has to try to make it consistent with any family violence order which is in existence. Now that section has not changed. It's always been there, it's still there. I don't think it possibly gets made enough of in the courts, but it's still there. The other one that is still there that is critically important is section 68R, which says that a state magistrate is entitled to vary a parenting order if they feel that they need to when they're making a family violence order in a state court. Now there's a lot of research which has been done to suggest that this section just doesn't get used as often as it should, and so that is a problem. And in fact the Australian Law Reform Commission recommended strengthening that provision to basically require magistrates to consider doing this, but that didn't get up. There was also, the ALRC also suggested strengthening that section I looked at before, and that didn't get up either. So, we see that some of the suggestions that were made did not get through the system. Now, I want to just quickly have a look at this section because I think it does. Okay, I'm going to do this one and one other thing just to show you what I think is a concern. Back in the 1995 reforms, which those of you who've been in the sector long enough know was the first real area of concern for advocates in family violence, in family law reforms. But at that point, the old section 68F2J used to say that the court could take into account any family violence order that applies to the child or a member of the child's family. When they brought in the 2006 reforms, there'd been all complaint about that. And all the complaints are based on the idea that women lie about violence and that family violence orders are too easy to make. That's the background. So they changed it so that it could that only got taken into account where the order was final or contested, on the basis that sometimes when orders are made, it's all just nonsense. A woman came in and said this because she thought it would be a good idea and the magistrate went, good for you, and made an order. So they made it more specific. Now, this all became very political during the next stage of the process, was discussed a lot in Richard Chisholm's report and in the ALRC report. So now we have this incredibly complicated section where what we're now allowed to take into account is any inferences that can be drawn from the making of an order, but we have to take all this stuff into account, the nature of the order, the circumstances, any evidence that was submitted, any findings made, etc. Now look, actually that was very well supported by people. Everyone thought, look, that gets rid of, at least we're not relying on the order anymore, it gets rid of this argument and the argy-bargy about whether women lie or not, because we just bring all this stuff in. Sorry, but do people understand that transcripts cost money? That it takes time to order one? Now, the fact you've got an order means nothing, and what we're going to find is magistrates' courts being overwhelmed by applications for copies of transcripts of DV hearings and magistrates' findings, which cost, it costs a couple of $100 minimum to get that stuff, and probably more, as I understand it from the inquiries I've made. And really, what's it all about? Women lie about violence. that I still see. That is the message. Those sections with those complicated wordings continue to tell us that women lie about violence. That's why they got so complicated. There's no other reason. And this is what, why do we have to do this? I just think actually get rid of that provision. If you've got to prove the evidence again, why not just put it in the affidavits now? Why would you bother getting it all from some other place? I think, because family violence itself is still a matter to be taken into account. I'm just beginning to think, get rid of the provisions about family violence orders, because all they do is carry this, this overt message that family violence orders are not to be trusted as meaning that there was ever family violence, and a covert message that women lie about violence. Now, in the remaining 1.5 minutes, can I show you these couple of things? Here we are trying to get consistency. Now you'll see actually that the Family Law Act is fairly consistent with the ALRC suggestion about family violence. You'll see some very similar words here. Here's my little, it's so beautiful with the doobie, I'm great at PowerPoint, but there's all my little lines. So you can see actually most of them match, but interestingly, the Family Law Act talks about social and or cultural isolation, which wasn't part of the ALRC recommendation. So I think that's an excellent addition. What does worry me though, what I do want to explain to you is a very important aspect of this, and then I will have to sit down without having told you a couple of other things. The way the Family Law Act is now written, you have to, this preamble bit to that clause, family violence means violent, threatening or other behaviour by a person that coerces or controls a member of the person's family or causes the member to be fearful. And then you have the examples. Now let me make very clear to you a very important thing. What that means is that any of this behaviour on its own is not domestic violence. You must also be able to show that that behaviour was coercive or controlling or leads to fear. Family violence is behaviour that has these characteristics, and then you've got your list of examples. Now there's some very good reasons why that has been done, because some of the things here, if you're not talking about coercive and controlling violence, may not really be domestic violence. But I actually think that linking those things is going to mean that there are a range of pieces of behaviour that we might in the past have called family violence that will now be excluded, because it will not be possible to reach that test that is the mandatory prerequisite or the mandatory accompaniment to the acts. Heather, is that time? And
no,
I should.
You can keep going.
Oh,
you've got. I think I probably held
okay,
it a little bit early. So
all right, okay, all right. I'll do a couple of other things, and I'll flag a couple of issues that you might like to come back to in the panel rather than cover them in detail. So, but you see here, so this is the Domestic Violence Act definition. So they went down a completely different path in the end. They've got their controls and dominates, and they've got their coercive, but they haven't set it up like with a preamble at the beginning. They've just got their different examples of kinds of behaviour. Now, I actually don't know which one is going to work better. I'm not too sure. I think there's advantages and disadvantages in both. But if all of this reform was supposed to be a way to create greater consistency between definitions of violence in our state courts and in our federal courts, we failed totally and completely, because actually each lot went exactly the way that they wanted to, which is not consistency at all. But anyway, it gives us an opportunity to see which one works best, I guess. Except remember that magistrates are doing a very different thing when they're applying their definition and have very different context to do it than when family court judges are applying their definition. It's not just the words, it's the whole context of the circumstances. This act is about protection, the other act is about what kind of parenting order should I make, knowing that there is this policy notion behind the Family Law Act of shared care and shared parental responsibility. I won't go through that for now. And I think I've started to really say this to you, this whole idea of coercive control. I think it's very useful in a lot of ways, but we have made it now a prerequisite in the Family Law Act. And what I want to bring back into your minds is one of my greatest concerns about this is, again, this influence of social science into the law. One of the things that really worries me is that some of you will be aware of that typology literature that is doing the rounds that everyone talks about, where we're told, depending on which piece you read, there's 4 or 5 different kinds of domestic violence, different typologies of family violence, and one of those typologies is coercive and controlling violence. And other typologies are, think, common couple violence, whatever that is, separation instigated violence, which is apparently not coercive and controlling violence, what is the violent resistance and something or other else. Now, what worries me is what happens if these definitions and that social science start to get conflated, so that really judges are going to start to read that definition we've now got in our Family Law Act as somehow being linked to those social science definitions. And my big question, my big issue there is this starts to have an exclusionary effect. There's one kind of violence that's family violence, which is coercive and controlling violence, and every other kind of violence that might be happening is not. And so what worries me is that this kind of definitional format that's been used may prove exclusionary. Now, so my final point is this, though, that what happened, though, is that the presumption that equal shared parental responsibility is in the best interests of children was not repealed. Of course, that was one of my suggestions. Of course, it didn't happen. I'm waiting for 2020 when I get to rewrite that submission again. But so the presumption was not repealed. So but remember, so in theory, as Ray said, the law says if there's family violence, the presumption is rebutted. But let me use some of Ray's research on this. Actually, what we know is that in 75.8% of cases where family violence and child abuse were alleged, orders were made for equal shared parental responsibility in our court. So it is an exemption that plays out about as well as the exemption in relation to going to family dispute resolution. It is an exemption that is entirely breached in practice. It has very little meaning. It is just breached and breached and breached. But that presumption has an inclusionary effect, because the wording of the presumption is you're all in unless we decide you're out, and actually we often don't decide you're out even if you're an exemption. So we have a domestic violence definition which is exclusionary of matters in terms of what is domestic violence, and a presumption which is inclusionary of everybody. And now I will finish, thank you.
I wanted to start off with just an anecdote, which was I'm running a clinic with students at Caxton Legal Service on Wednesdays with criminal matters at the moment. And the receptionist was on the phone to somebody and she said to me, Heather, I just need to ask you something. And she said, how come when a woman is assaulted and it's a domestic violence context, how come the criminal law is not relevant? How come, why is that? So please explain that. And I said, well, actually it is relevant, and tried to explain what the story was about this. So there is this understanding in the community, I think, that there is domestic violence legislation which deals with criminal justice matters as they arise in a domestic violence context. And of course, we've struggled with this link and how these two interact, these two systems interact with each other for some time. So basically, Zoe set out the domestic violence legislation, or some of the key issues in terms of the developments in that for this forthcoming piece of legislation that we have in Queensland. And essentially that legislation is looking forward for victims of domestic violence in order to prevent further violence against victims, whereas criminal justice processes are to some extent looking back towards punishing or dealing with offenders who have committed acts of domestic violence. So they are different processes, certainly. However, one of the things in the domestic violence legislation, one of the aims of the domestic violence legislation, is that perpetrators should be taking account, or should be accountable for the violence they commit. And one way we can ensure that perpetrators of violence are made accountable is through the criminal justice process. So there's certainly a role of these two processes to operate in a parallel way, operate at the same time. I noticed though in the protocol that's been developed by the justice system to help workers dealing with this new legislation doesn't really deal with information giving around criminal justice processes, and I think that possibly is a gap that might be addressed. In terms of the overview of what I want to talk about, basically I wanted to talk about some of the problems with the criminal justice systems dealing with domestic violence, dealing on some of the research I've done in the past. I'm focusing here on lower court matters largely, more summary matters and matters that would be heard in the magistrate's court. There are lots of developments for matters in the higher courts to deal with serious offences such as unlawful killing or homicide. There is an issue of Australian New Zealand Criminology Journal coming out in December with a selection of articles addressing the response to homicide and domestic violence cases, which some of you may be interested in, and I've written there about the Queensland response at that higher level. So today though I'm talking about the lower level response of the criminal justice system. So the way I wanted to proceed with this was first of all just to overview the problems with the criminal justice system, then talk about what the ALRC said and what the new DV legislation might do differently, or what criminal justice responses might do differently as a response to this legislation, and then some, perhaps might be too strong to say promising directions, but certainly I'll try to suggest there are some, and identify some issues of control. I wanted to go way back in time to 1989 to Carol Smart and Mary Jane Mossman. I know that seems like a long time ago, and I sort of think about Zoe when I think about this, because you could roll out the same submissions and Carol Smart could roll out these same points and problems with criminal justice right now. And way back in 1989, when she talked about feminism and the power of law, she talked about these problems with prosecuting rape matters, but these problems exist also with prosecuting domestic violence matters. She talked about concepts of boundary control, relevance and case analysis being the core issues in relation to legal method, and how these really were not well adapted to criminal justice prosecutions of things like rape and domestic violence. In terms of boundary control, I wanted to draw on some of the comments made to me in a research project I conducted with Tanya Stark, who some of you may know. We interviewed 20 women, very small sample, qualitative sample, about their experiences with criminal justice and domestic violence and how they experienced that process. And really, I've kind of summarised all of this information into an article, which I'll give a reference to at the end of this paper. But I think Carol Smart and Mary Jane Mossman's work really summarises the problems that continue to exist, and these women essentially identify them. So in terms of boundary control, we're trying to say, I think we're trying to talk about here this idea that the criminal law is said to cover certain things, and we think of it as covering quite traditional ideas such as assault and criminal damage. And there is a reluctance to see the developments in relation to understanding domestic violence threats or stalking and those kinds of ideas as possibly matters for the criminal justice process. So some of the comments made along these lines came from both women about police responses, but also about their own personal attitudes to this interaction between domestic violence and criminal justice. So, for example, the first quote there, the police officer said to me, "He hasn't actually sort of done anything, has he? It's all just threats." This was trying to report a breach. He made the reference to 4 pages of notes with no violence, no cuts, no bruises, no bashing, no domestic violence. So this idea that there's a boundary between physical assault and the stuff, which is the stuff that goes for the criminal law and the criminal code, and then the rest of the stuff which goes in the DV legislation. And there is actually much more of an overlap, of course, as most of us in the room would know. But this is a woman's quote down the bottom. "I've seen my mother beaten up for years, so I defined domestic violence or criminal justice responses to domestic violence as an issue of physical violence. I didn't get any bruises, so therefore it's not. It just stays in the domestic violence sector rather than crossing over into criminal law." So I think boundary control comes from both sides. It comes from both police officers dealing with these matters, but also from the women themselves who aren't identifying this as a matter for criminal law for lots of reasons. The other thing is relevance, and the idea of the relevance of evidence and which evidence gets in and is relevant. And this is something that was picked up by the ALRC report. So when women have reported domestic violence to police, they've noted they charged him with drink driving, unlicensed driving, speeding and all of that, nothing to do with me or domestic violence at all. And I said, "Why can't you do anything more than that?" And he said, "Well, there's no evidence." This is a situation where he'd driven one of the children away and speeding the car. The second one there, we did not want to show our hand to that. At that stage about this recording device, the only way that I could get the evidence was to actually record him, and he has assistance of a lawyer to do this, and this makes his world real and credible and you're mental. So these were quotes from women. So the first one there says that there's a reluctance to collect the evidence that's relevant to perhaps prosecutions that might be relevant which relate to domestic violence specifically. The easier road always is to take these prosecutions of, say, traffic offences or assaults or violence against third parties who may be present at the scene, such as violence against other police officers, for example. So this claim that there's no evidence. And the other point there, the second point, is that women do know what evidence they need, and really the suggestion here is that women have to collect their own evidence. And certainly a lot of our stories were about women collecting their own evidence, which really isn't what the victim should be required to do. It actually is a role that others in the criminal justice system should be playing. And then the problem about lawyers and how lawyers can kind of figure out what's relevant and what's not, and how they manage to paint a picture of victims in a certain way in order to protect the perpetrator's interests. So this was a concern that some women suggested as well. And finally, at the other end of this stage, I think, where matters do get into the magistrates' courts as prosecutions of breach or other criminal matters, and then there's a problem of case analysis, which really relates back to the doctrine of precedent in criminal law, where magistrates, judges follow precedents, so previous cases. So there is a system now in place, I think in Queensland it's fair to say, that if there's a breach of a domestic violence order, a fine, for example, is appropriate, and this is the precedent that other magistrates follow, despite the fact that many of us would suggest perhaps that fines are not actually the most appropriate way to proceed in these matters. So I think these ideas from the 1980s, unfortunately, still percolate into our current ideas about how criminal justice works at the present time. So then, to go on to the Australian Law Reform Commission's report in 2010, they actually provided or covered criminal justice issues in 5 chapters. I mentioned 4 here. So they obviously saw this issue as an important issue, criminal justice in the domestic violence sphere. I wanted to mention 4 of the chapters. There's one missing there, chapter 10 on bail, which I won't go into. But I just wanted to basically take some of the key ideas out of these 4 chapters and talk about how they were discussed in the ALRC's report and how they might percolate into our current response in Queensland. The first, I think, radical idea in terms of the Queensland situation, not so much in other states, but certainly in Queensland, was the development of police-issued orders. So this is a situation where police don't have to go to court in order to get a protection order, and should these be introduced. The ALRC matter, the ALRC report discussed this issue, and they were concerned on the left-hand side with a number of matters. One of them was that this kind of question is a question for judges. Another issue I think is interesting is that getting women into the court system often is a good way to introduce them to support services. By going just through police, they're not getting in touch with those support services that may, in the past, have been available to them. Might not get proper explanations, might set up people for breach, not only in these contexts, which might create a whole new set of problems and prosecutions and people defending those breaches quite actively. So we might have a whole situation where people don't understand their orders so clearly, and so there's more opportunity for breach. And this is something that Zoe identified, the issue of identifying a primary aggressor in police-issued orders. Do police have the capacity and training to be able to do this? And the ALRC were worried that maybe they didn't. They said that they were, in the short term, not particularly useful for lots of reasons, but in the positives, there were a number of positives identified. In fact, that victims do avoid court, they don't have to go to court to get these orders. They're a quick response, it's a crisis response. There's time, you can add time-out conditions to a police protection order, which might mean that the person has to stay away overnight from his home or whatever. In rural areas, obviously, access to court's a problem, and it's very important that breaches are followed up in this context to make these police-issued orders have teeth. And if that's happening, that could be quite useful. There's also this possibility of short-term cool-off orders, so similar to time-out kinds of concerns. So we have introduced these in the forthcoming Domestic Violence Act, which I think is an interesting development, an important development, and it does have some protective features in terms of when they can be issued. I think that is this the best response in the circumstances? So the notice is necessary or desirable and there are no other existing orders in relation to domestic violence. There has been a commission of domestic violence, and it's not a situation where the respondent should be taken into custody. So they're the threshold questions. The interesting point here, which should avoid this situation we're seeing increasingly and very problematically, as Yasmin in the room knows, about cross orders where police are involved in applications for mutual orders on behalf of both parties. Under this legislation, that shouldn't happen anymore. So that's, I think, a very important provision here. We can still have cross orders issued by magistrates, though, potentially, but this shouldn't be a situation where police can issue notices on both parties. They can't, according to the legislation. They also have to eventually get to court within 28 days. And as I said, the ALRC suggested cool-down conditions, and they will also exist as possibilities. There'll be standard good behaviour conditions associated with these police protection orders, but there's also the possibility of cool-down conditions. And I think very importantly in the cool-down conditions, perpetrators can be ordered to stay away from the family home, even in situations where they have an equitable interest in it. So that's very clear in the legislation that it's possible to order effectively ouster orders in these conditions, in these situations. So I think that they are all very important developments that have happened as a result essentially of the ALRC and subsequent reports on this question. In terms of protection orders and criminal justice, there is provision in the Penalties and Sentencing Act, and there has been for some time in Queensland, that non-contact orders can be used. These are rarely used though. They have been used in some stalking cases in the higher courts, but they're underutilised, I think, by courts. Sometimes this is because there are already domestic violence orders in place. This is something that the ALRC recommended should occur, that non-contact orders should be available in criminal justice, and we've jumped the gun here. We've had these available for some time. The other point that the ALRC mentioned was that there should be power for the courts to make protective orders at any time during proceedings. This is not possible in Queensland until there's a conviction. So certainly when there's a conviction of an offence involving some form of domestic violence, then an order can be ordered. So maybe there's room for a broader power to be introduced there. The other thing that the ALRC suggested was that in sentencing, courts should be able to take into account the conditions of the DVO and how long it's been in place. We haven't introduced that into our Sentencing Act, and I don't think there's any plan to. The Sentencing Act under Section 9, though, is very broad, so submissions could include things about the conditions that have been breached and the kind of conditions that exist. So Section 9 of the Penalties and Sentencing Act allows the magistrate or the judge to take into account any other relevant considerations. So it's incredibly broad, so it should be able to deal with that particular issue. In terms of breach provisions, as I said, that a person who's issued with a police protection order in Queensland under the new legislation, there is a possibility, and the ALRC noted this, and we have introduced it into this forthcoming legislation, that a breach of a police protection order is a breach offence. So breaches of domestic violence protection orders, the old-fashioned kinds of breaches, obviously are still criminal offences, but breaches of the new domestic violence legislation police protection orders are also a breach offence, and they're both very serious breach offences. They can lead to imprisonment. So there really is strong teeth, arguably, associated with these breach provisions. But I should say they're summary offences. Now, what summary offences means is that they are heard in the magistrate's court, but it's also a message to magistrates they are a lower level of seriousness in the kind of hierarchy of offences. So even if a breach actually includes a whole lot of fairly serious issues, it is still prosecuted as a summary offence, or it can be prosecuted as a summary breach offence in the magistrate's court. So it keeps it there in that low level, arguably trivial offending category, perhaps along with things like urinating in public and those kinds of summary offences in the Summary Offences Act. So that's where it remains in this new legislation, and I wonder if that's appropriate. The ALRC also recommended that aiding and abetting a breach, a person who is protected by a DVO should not be able to be charged with aiding a breach. This has been introduced into the Domestic Violence Act. I think this is really important, so that the woman who is on the phone to her partner or ex-partner and says, sure, you can come around, and he comes around and picks up something that could be breached, and she cannot be charged with aiding and abetting that breach in that context. So it is entrapment to some extent, potentially, but this legislation would protect from that kind of behaviour in those circumstances. So that's something that we did follow up on in response to the ALRC. The ALRC also accepted that there was a tendency to charge breach instead of substantive offences. I demonstrated this in research that I did a few years ago, and they picked up on that research and accepted that that was the case. And certainly I think this is a real problem, partly because of substantive offences show up on the criminal record as the substantive offences of assault, criminal damage, whatever it might be, whereas breach offences show up on the criminal record as breach, which could mean making a telephone call, or it could mean something much more serious. So I think it is a problem that we have had this issue, and it's something we need to take seriously. The ALRC recommended that guidelines should be updated to educate about double charging concerns. There has been a concern expressed that people can't be charged with both breach and the substantive criminal justice offence. In most cases that's not a problem, because the breach offence is effectively a contempt offence, that they've disobeyed a court order, whereas the other substantive offence might be the actual assault or the criminal damage. And the courts, as I'll show you hopefully, have been willing to recognise this as a possibility, that double charging is not a double jeopardy situation necessarily. It's a matter of looking at particular facts to check whether there is actually overlap or not. There isn't always. In terms of guidelines from the ODP guidelines, these are the guidelines that the ALRC were referring to. These are on the web, the Office of the Department of Public Prosecutions, for those who want to look at them. These are guidelines for charging that police and prosecution services use to work out what to charge and when. And you'll see there that the first guideline obviously is there must be sufficient evidence. If there's not sufficient evidence, this can't go anywhere. But the second guideline says if there is sufficient evidence, then there are public interest questions, a whole list of concerns and issues that might be taken into account. So public interest is one of those. You'll see though that from guideline 13 there should be a preference from prosecution for summary charges unless there would be inadequate punishment. So breach charges in many cases, according to these guidelines, should be preferred unless the penalty associated with the breach charge is going to be inadequate. There's also this pressure on police. They have to be able to only continue with charges they can reasonably prove, and their guidelines say that. So this might be a reason why they pull out of substantive offences. And they should apply for a domestic violence order if the person's convicted of a DV order, so there's pressure on the magistrate or the courts to do this, but there's also this provision in their guidelines for prosecution as well. In terms of other things, the ALRC said in Chapter 12 they wanted better data capture, something I think all of us have been talking about for years and years and years. Yes, we want better data capture, better education for everybody, women, DV workers, police also. The idea that non-violent breaches can be very harmful to people, and they are not trivial necessarily. Just because they're phone calls, it might be actually quite harmful, and it might make the woman quite fearful. Also, more and better education about the impact of fines on families. Who's paying these fines? Is it actually the woman who was violated rather than the perpetrator who's been charged? Is the money coming out of the family pool, or is it coming from somewhere? So the impact of fines can be an important consideration for magistrates. The ALRC, though, did say there shouldn't be any mandatory penalties. There was discussion about this, whether there should be a minimum mandatory in the legislation. They did not recommend that, and we haven't introduced that in Queensland, so it's very discretionary. And of course, we could get to the top of the scale at 3 years imprisonment, or we could get to the bottom of the scale as a, convicted and off you go, or no conviction bond. So we could expect that variation, depending on the individual circumstances, that will continue in Queensland. The problems with substantive offences are really what I outlined at the beginning, but the ALRC also went through these issues too. And they talked about domestic violence offences, and this is a little bit similar to your contrast between family law and DV legislation, the difference between, I suppose, domestic violence legislation and what criminal law requires. There are quite a few, I suppose, problematic connections between the two. So if we have a course of conduct, which is often what we're thinking is really the problem for women, is this is a continuing course of conduct. Each little bit might not look like much on itself, but when you look at the course of conduct, it is very harmful. But the criminal law relies on discrete incidences. Stalking is a little bit of an exception here, but as a general rule, assault, we have to identify that single assault, we have to have evidence for that single assault, that single incident of criminal damage. So this causes issues. Late reporting as well can be a problem. So if women at the scene of the crime say, no, I don't want to continue with the offence, But 3 days later, after she's spoken to her DV worker, she's feeling much more confident and strong. Then she might want to continue with a complaint in relation to criminal justice. This might be something that works against her because she looks like she's not so credible because she's reported it late. So this might be something that's reported to the court on behalf of the perpetrator. She might tell her doctor that she walked into a wall. He might have a whole lot of evidence of black eyes and bruising and all sorts of things over a period of a year, but the story that she tells her doctor is a whole lot of other different stories, and this will make her impact on her credibility and will also mean there isn't any evidence of domestic violence. She might have told close family friends, but they can't really come to court and give this evidence because it's hearsay, so it would be excluded on that basis. Friends and neighbours might have heard things. They might be able to come to court and say, I heard lots of shouting and banging. It's weak. It's not the best evidence. We want visual evidence. We can see what happened and we're involved and we can tell the court what happened. So it's weak evidence. And the lack of evidence of injuries, they might have healed long ago. A lot of the people that we interviewed said that the fellas that were bashing them knew how to bash them. They'd pull them around the throat with their shirt and pull them along the hallway so their head hit the architraves, and they'd have bruises all over their head, but nobody else would see these bruises. So there was no visibility of bruises to people that were looking for evidence. And so this is obviously a problem for criminal justice as well. Now, in terms of the ALRC and what their recommendations were, they talked about a whole lot of possibilities here to redress this problem. I think what we're trying to do here is try to make criminal justice processes work better in parallel with domestic violence protection order legislation. So this is what this debate really is always about. It's not about getting rid of domestic violence orders by any stretch of the imagination, replacing it with criminal law. It's about making better use of criminal justice responses in certain contexts. Not all, but some. And so the ALRC suggested a number of things, such as an umbrella offence, like a domestic violence offence, but they couldn't see how that would work, so they said no. Should family violence be an aggravation for an offence? Should it make it worse because this has happened within a family? There are problems with that because all sorts of other situations might be a suggested aggravation, like teachers and police and so forth. So they said no to that one. In terms of whether police should use representative charges as a way of presenting a course of conduct, they said that could be in guidelines. So if there is a history of course of conduct, that might be all represented in one assault, and there might be evidence of those other ones presented as well. And finally, should course of conduct be a sentencing factor, a mandatory sentencing factor? Not necessarily, but it could be introduced. I'll come to that in a minute. And family relationships as a non-mitigating factor, they said that yes, that should be a non-mitigating factor. Not that it should be an aggravating factor, but that it shouldn't reduce the seriousness just because these parties are involved in a relationship when the assault happens. They basically relied on bench books, which are guidelines for judges and magistrates, which are all available on the web in our various jurisdictions, and guidelines for prosecution guidelines. Now the problem with these two things is they're discretionary, they're simply guidelines, so they're suggestive, so if they're not followed, that would be okay. There wouldn't be any breach of any conduct rules or anything like that. So that was what they suggested we should rely on, and that's the position we have retained in Queensland. In terms of promising directions and issues of concern, I guess that looking at the case law, I think that if we can get these criminal justice matters to court, magistrates and judges are often very responsive to the concerns. And you can imagine that they're often confronted by a perpetrator who is well represented, who is often pleading not guilty, and so with perhaps in many cases a less well-resourced prosecution team, because these are often lower level offences. So, you know, I think we have to rely to some extent on the response of magistrates and judges, so they need to be well educated about these issues as well. I just picked out a number of cases here that have looked at domestic violence. It is hard to get reported domestic violence cases because most of them are in the summary courts, so we only get to read these cases as a general rule when they get reported as matters of appeal, and even then only when they pick up interesting issues that the court puts these matters on the web. So it's a very limited pool of reported cases that we can draw on. But in this particular case, the perpetrator put evidence before the court that she really was partly to blame here. She'd been being ambivalent to her partner, and the relationship was fractious. Now, he said that evidence had little weight. It carried little weight for his view of the matters in terms of sentencing. So I guess that's better than having a lot of weight. Arguably, he should have said it was irrelevant, but anyway. In terms of course of conduct, I thought this was interesting. I've already set out the problems with charging substantive offences and assault and criminal damage. In this particular case, this fellow was charged with breach. And in prosecuting the breach, the prosecution put before the court all of the evidence that was actually evidence of assault and criminal damage and the matters. And the question was, should that evidence of assault and criminal damage have gone before the court when this was a prosecution of a breach? And the court said they could accept this because this forms the narrative of the act of domestic violence constituting the breach. I think that's really important because that brings a breach, which could be just a breach of a court order, into a much more a context which judges and magistrates will take much more seriously. They can hear that narrative, and they were prepared to hear it in that case, which I think is important. Another thing that the Australian Law Reform Commission recommended in their report was that there should be better use of victim impact statements. I think this would possibly be helpful for women who are involved in prosecutions, but also for courts as well. They are a bit of effort, and they're an effort primarily for prosecution services, so they're quite time-consuming. The Victims' Offences legislation, which relates to compensation claims in Queensland when people are prosecuted with offences, has provisions under Section 15 where victim impact statements can be put before the court. So this does give the victim an opportunity to air the kinds of things that she's experienced, which don't add actually up to criminal offences. These are not criminal offences. She's lost her hair, she's got ringing in her ears, she's lost the feelings in her fingers, she's depressed, she's anxious, she's on sleeping tablets, she's constantly afraid, she's alienated from her friends, the kids have behavioural problems, she's in a difficult financial position, all as a result of this context of domestic violence that she's lived through. This was a prosecution in major, and these were the kinds of things the judge was prepared to take into account through the victim impact statement. So one of the things I think domestic violence workers could do is push for victim impact statements to be presented in these cases where they do get to court. I think they're probably helpful for everybody involved, except perhaps the perpetrator. So I think that is something that is available to us. The ALRC recommended we use them more, and I think it's possible that we could do that. I can finish there. The report, the ALRC report, is obviously over 1,000 pages long, I think, so there's a lot to read, but it is a fantastic report. The information that I presented at the very beginning of the women's interviews are in that article, which is available. Feminist Legal Studies just came out last week. Essays in honour of Carol Smart. So if you want to follow that up, it can be found there. Thanks very much.
Fantastic.
I just wanted to say first of all that I'm going to actually talk about the domestic violence provisions or family violence provisions in the migration regulations, and I'm going to talk a bit about the background of it. Then I'll speak a little bit about the technicalities of it, and so that might be a bit kind of boring for some. And then I'll talk about some of the changes that have occurred and the recommendations that are coming. Okay, so the first thing I wanted to say is access to justice and equality before the law. We would agree are important principles to any notion of fairness into the legal system of a democratic country such as Australia. So it was, I believe it was these principles that saw the introduction of the domestic violence provisions, forerunner of the family violence provisions in the Australian migration law in 1991. The provisions are intended to protect people. The vast majority of them are women, of course, who are being sponsored by a permanent residence or a citizen in Australia, or who can be included in the partner's permanent residence application as well, and they're being subjected to violence by their partner. The power imbalance, which is fundamental to an abusive relationship, is often characterized on the immigration context by statements from abusive partners that you all probably have heard along the lines of, I'm an Australian citizen, permanent resident, and I can get you Australian residence, but without me you can't have it. It was only after much lobbying by Immigrant Women's Services and other women's services in Australia that the provisions were introduced into the legislation to protect women who were faced with the choice of either leaving the abusive partner and thereby losing the access to immigration permanent residence, or remaining in the abusive relationship and being subjected to continued domestic violence. For many women, and we all know that women in general have a significant investment in the relationship, and that could be emotional investment, financial, social, or any other, in the relationship, but also these women had a significant investment in the transition to life in Australia. So the choice was very difficult to make. Leaving the relationship and returning to the home country often meant returning with nothing, no money, no home to return to, no job to go back to, and in some cases it meant being faced with shame, blame, and social isolation by family and community in the home country. And in some cases, we know, it meant returning to face physical harm. The Equality Before the Law report published by the Australian Law Reform Commission back in 1994 found that the legal system failed women in several key areas and identified several issues of concern for immigrant and refugee women. These included the abuse of sponsorship of women as spouses and fiancés, women brought into Australia for the purpose of prostitution, the lack of recognition of women's issues granting refugee status, and the detention of illegal entrants. All issues which continue to be on the agenda today, 18 years later. So I agree with the concepts about the 1989s and 1990s. And Zoe spoke about as well in terms of cut and paste. So a lot of this stuff probably I have spoken about before, many years ago. So that report made several recommendations for change, and since that time there have been many recommendations implemented and other developments have occurred. For example, shortly after the report, the migration regulations were amended to limit the number of partners one Australian citizen or resident could sponsor. So now, one sponsor is limited to 2 overseas sponsored partners only in the lifetime, and the sponsorship must be 5 years apart. Now that was introduced by the Howard government, funny enough. However, there is provision obviously in the regulations for the limitation to be waived in exceptional circumstances. So things like if a spouse dies or if there is a child of that particular relationship, so they could, there is a child and that can be waived. So there's always a possibility of bringing another partner. So this particular amendment was introduced after concerted lobbying by women's services again that had identified the issue of serial sponsorship as a major concern. Since the 1994 report, there were also significant developments with respect to the domestic violence provisions in the migration regulations, and some of these have facilitated victims' access to the provisions for permanent residents, but other amendments have actually made it much harder and much more difficult for women to access permanent residence. So to understand the amendments, we must first take a brief look at the regulations and see how they work. So the legislation requires that the applicant for a permanent partner visa must be found to be, and this is really important, they must be found to be in a genuine, continuing, and exclusive relationship with the sponsoring spouse at the time of applying for the visa and at the time of decision of the visa application. If that relationship breaks down before the application is decided, that visa will be refused as the applicant does no longer meet the relevant criteria. However, a visa can be still granted even though the relationship has broken down in certain prescribed circumstances. And these are that the Australian resident or citizen sponsoring partner has died and the applicant has close ties to Australia. So it can be anything like employment ties, family ties, business ties. This aspect of this exception is actually interpreted quite generously by decision makers. or the sponsoring partner has perpetrated family violence against the applicant or against a member of the family unit of the applicant. So that could be a child, or could be even a parent that lives with them. Or the applicant and the sponsoring partner both have ongoing legal responsibilities towards a child or children of their relationship. This is what we usually call when we talk to workers is the child, oh great, the child of the relationship, that's easy. The legal responsibility can include taking part in daily care of the child or having access rights or whatever it's called today, having decision-making responsibilities towards the child, things like that. To qualify, though, for permanent residence under the family violence provisions, the applicant must satisfy the definition of family violence found in Regulation 1.21 by providing evidence of domestic family violence in a prescribed form, which is also found in Regulation 1.22 to 1.27. The regulation specifies that at least one of the following forms of evidence must be provided. No other forms of evidence are acceptable. The evidence is grouped in two categories: judicial evidence and non-judicial evidence. So, judicial evidence is pretty self-explanatory: restraining order, domestic violence protection order, or an injunction order by the court. Important point here is an interim order is not sufficient. It used to be, but it's not any longer. A conviction of finding of guilt against the perpetrator in respect of an act of violence against the applicant, or a member of the family unit of that applicant, or a court injunction under the Family Law Act. Now, non-judicial evidence, really difficult area. A joint undertaking made before the court by the alleged victim and the alleged perpetrator. This must be signed by the magistrate, so it's not, some of those undertakings that are made outside the court, they're not valid, and that's important. Or a statutory declaration by the visa applicant or the victim, or the person who is making that statutory declaration on behalf of that person or the applicant, and either two statutory declarations by competent persons in different categories of profession, so it can be the same type of category, and one statutory declaration by a competent person and one police record of assault. That is a record kept by the police service of a state or territory, not just a statement by the alleged victim. So another important point. The amendments providing for non-judicial evidence were included as a result of the Australian Law Reform Commission report of 1994, which identified difficulties women facing going to court. I mean, we all know that women really find it difficult to go to court to seek protection from an abusive husband, and we know the reasons for that as well. A lot of women believe that it will bring shame to the family, that the children will suffer, and lots of other reasons. Another reason why the non-judicial evidence was introduced was because in deciding whether or not to grant a family violence protection order or restraining order, the magistrate in Queensland, say, had to assess likelihood, and so of future violence occurring. And we know that that wasn't necessarily the case for a lot of women, because women possibly would have left the relationship, they would be in refuge, they would have moved away. Sometimes the partner would have probably just discarded them and had nothing to do with them. Whereas the definition of family violence to be satisfied under migration law requires that there has been violence during the relationship, not after the parties have separated. So that's a hiccup, or was a hiccup. The assessment of future violence is not a relevant consideration in the migration context. This is a significant difference, which warranted the introduction of an alternative form of evidence in the migration law context. So once the applicant provides judicial evidence as evidence of the domestic violence, they are granted permanent partner visa reasonably quickly. Where the applicant provides non-judicial evidence, there is often a lot longer period of waiting for the decision as to whether they will be granted permanent residence. Now, why is this so? I mean, we probably have a lot of ideas about why, and I think, I suppose one of the things that I picked up from Zoe's presentation was that issue of women lie, and I think possibly that's one of the major reasons. So the other reason is, of course, that the immigration department officers cannot question a court order or conviction or injunction that is made by a court of law. So they're not always willing to accept other evidence that is made by competent persons. The domestic violence provisions in the migration regulation have been a controversial provision. Since the introduction in 1991, they have been reviewed at least 5 times, and they're currently under review once again. It seems disproportionate when we see the numbers of people accessing the provisions and thereby acquiring Australian residence. And here you've got some numbers, quite apart, so that we can show the difference. For example, in 2001, out of 33,088 partner visa granted, 473 were granted on the basis of domestic violence provisions. That is only 1.4%. And in the financial year 2010-11, and I couldn't find the figures for this last year, of 41,994 partner visas granted, 1,023 family violence claims were made. That is only 2.4%. Now, what's interesting with that figure, and I didn't have it there, is that out of the 1,023, about 208 were sent to the independent expert, and we'll talk about that in a minute. So I think a lot of attention for such a small visa outcome, such a small percentage visa outcome. Why is this? Obviously, we know, in this area, men's rights groups lobby heavily. We also know that conservative governments listen to that lobby, and they probably agree with some of those sentiments as well. So, we hear all the time, and I believe we hear in the television as well, she claimed violence, but there was no violence. She convinced a competent person that she was a victim, but there wasn't anything, and so on and so on. For these reasons, recent amendments include that the violence or part of the violence must have occurred while the marriage relationship or de facto relationship existed between the alleged perpetrator and the spouse or de facto partner of the alleged perpetrator. Now that's really problematic because we know that a lot of the domestic violence also happens after separation. In fact, a lot of the murders happen after separation. However, that is that recent amendment that has caused some grief. Another amendment includes that the court order restraining the perpetrator, and this is a you listen to it and you hear right all over the place, the perpetrator will only be accepted where the order was made after the court had given the alleged perpetrator an opportunity to be heard or otherwise to make submissions to the court in relation to that matter. Like I said before, the interim protection orders were good enough, and then they were not good enough. So the difficulty with non-judicial evidence. The other reason for the constant review of these provisions lies in the construct of the non-judicial evidence. The law is very specific about the requirements of the stat text from the victim of his applicant and also from the competent persons. If these requirements are not satisfied, the application for the visa will fail. Not necessarily because the person hasn't experienced family violence, but because evidence provided did not meet the prescribed legal requirements. And this is an area that is totally regulated. So the legislation is set out in Division 1.5 of the Migration Regulations, special provisions related to family violence. I think I better go to the other slide, I hope. Yes. For example, a statutory declaration from a competent person, as you can see, must meet 7 different criteria before it will satisfy the legislative requirements. Now, I actually highlighted the other 3. You count them and you say 5, but it's more than 5. Just couple together some of the last ones. Now, a lot can go wrong, and quite often does go wrong. For starters, who is a competent person? A competent person is also defined in the legislation for the purpose of the family provisions. A competent person can be only one of the following, and I listed them there for you. You can see it, but an important point, I'll just pick on a couple. A registered nurse who is performing the duties of a registered nurse. So it can't just be a registered nurse, it has to be performing the duties of a registered nurse. A social worker, same thing, that is performing the duties of a social worker. So, if it is not a statutory declaration from one of these prescribed persons, the application will fail. So, for example, a woman who lives in Charleville or Maroochydore who's been going to a counselling session with a qualified counsellor, say the counsellor provides a stat deck, that statutory declaration will not be valid and permanent residence will not be granted. If a person talks to a lawyer and the lawyer might write a stat deck on behalf of that woman, be the same case, it will not be valid because it's not in the prescribed list of competent person. So in areas outside metropolitan cities, accessing the appropriate competent persons can be quite difficult. Even knowing who is on this prescribed list is difficult, particularly if English is your second language. Complaints have been raised by various sections of the community, including the ALRC officers, that under the legislation, once the evidence is submitted in the prescribed form, the decision maker must accept the domestic violence has occurred. They cannot overturn an assessment of the competent person, thus the permanent residence must be granted. The only area where the delegate has a discretionary power is in assessing whether or not the relationship was genuine in the first place, or whether the relationship was contrived for the purpose of migration. Also, under 2005 amendments, the DA officer can refer the applicant to an independent expert if they're not satisfied in some way with the stat deck. So we'll talk about the independent expert, which I know caused a lot of grief to us. However, a visa application can be refused when the statutory declaration from a competent person does not meet all the requirements set out in the legislation. There have been numerous court cases which have highlighted inadequacy in the stat decks from competent persons. It is notable that most of the decisions from the court, though, relate to appeals against refusals where the applicant and alleged victim has been a male person. Regardless of the gender of the applicant, of course, the principles of interpretation decided by the courts are binding on decision makers. So, for example, Meroka versus the Minister of Immigration, Justice Ryan stated in summary that it is not sufficient for a competent person to state that, in their opinion, relevant domestic violence has been suffered by the applicant. The legislation imposes an additional requirement that they set out the evidence on which their opinion is based. And if that evidence indicates that the competent person has misunderstood the relevant definition of domestic violence, then the stat deck won't meet the legal requirements. In Allen and the Minister of Immigration, again, versus the Minister of Immigration, Justice Sandberg stated that the stat deck from the competent persons did not satisfy the legal requirements because it did not state that the experience of family violence caused the applicant, very important, fear or apprehension for the personal safety and well-being. Same things that you raised in the other legislation. And that this was required by the legislation. The issue was elaborated further in the decision of Drew versus the Minister of Immigration, where Justice Matthews said that the legislation requires not only an opinion that past acts of violence have occurred, but also an assessment of the state of mind of the alleged victim. So, you can see that the courts have made it very clear that the wording of the stat deck from competent persons is extremely important. The declarations must be worded in accordance with the legislation and Regulation 1.26 and the definition of family violence and Regulation 1.21. If they do not strictly comply, the application must fail, even if the decision maker believes that the applicant was a victim of domestic violence. So it's not easy for a victim of domestic violence to tell a doctor, psychiatrist, or anybody what is required from them to write in the stat deck. So even though these non-judicial provisions have been included to facilitate greater access to the family violence provisions that existed prior to the inclusion, there's still difficulties to overcome. We have not yet got the balance right, that's for sure. As Justice Wilcox stated in Ibrahim versus the Minister of Immigration, the regulatory regime is a triumph of form over substance. Amendments effective from July 2005 onwards. I've got 5 minutes! No! All right. Amendments from 1 July 2005 onwards included the provision for a referral.
It's all right.
For a referral to an independent expert, which is the key thing for us. In circumstances where the decision maker is dissatisfied with non-judicial evidence. Under the legislation, the opinion of the independent expert must be accepted by the decision maker, as we said before, as correct, whether this is a primary or review. So that's really important, because it means simply that if the independent expert has made an assessment that there's not domestic violence, regardless where you go to review at Migration Review Tribunal, or MRT, they must accept that as a final decision. It's pretty similar to the Commonwealth Health Doctor. So there's a lot of power in that decision. So policy gives guidance as to when the decision maker might refer to the independent expert, and it states the referral should be made where there is, and you can see some of those, and I won't go through them, you can actually have a look at it. Some of this is actually policy, and they have to follow this. And it's problematic if you look at it, because, say, information that is vague or ambiguous, conflicting evidence, some of the things that, for example, somebody tells a competent person one thing and another one not the same thing, then is ambiguous, is conflicting, is credible. And we know that women, for example, feel much better talking to somebody and tell them perhaps about the rape than not the other. So you're not going to have two, the very same statistics. And neither should you. That'd be crazy. But anyway, that's the way it goes. So, like I said, the decision of the independent expert is final. So, then we've been talking about the Commonwealth Attorney General, again, as the Australian Law Reform Commission, and that's what we've been talking about, to identify improvements that could make to Commonwealth laws to better protect the safety of those experiencing family violence. And so we looked at social security law, child support, and immigration law as such. And I know that you probably all know, they have made 102 recommendations for reform. One of the recommendations was that there will be a common definition of family violence in all Commonwealth and state jurisdictions. The definition. So, and this recommendation I've heard many times. I mean, as late as far as 1994-5, when the National Committee on Violence Against Women recommended the same things. The definition of the migration regulation, for example, currently differs to the definition in the many state jurisdictions. This has been a contributing factor to some of the difficulties with the stat text for competent persons. Because some of those competent persons might be more familiar with the state definition, and so they actually word it in that way. So, with regards to immigration law, the Australian Law Reform Commission has recommended that the family exception be expanded to cover other visa categories, to cover all secondary applicants for a short permanent visa, that is, members of a family unit of a person who is applying for permanent residence visa onshore. So currently the family violence provisions exception is available only to onshore partner visas applicants and to secondary applicants to a number of onshore skilled and business visa, but it's recommended that that coverage be extended. Currently, for example, also it's not available, and this is something that the women's sector I know has been lobbying for a long time, is not available to fiancé holders or holders of prospective partner visas who are in Australia but the relationship breaks down before they marry. And so now they're recommending that it should be available for that group of people, which would be a pretty good reform. We are aware of cases, obviously, that's, the women come here, they have 9 months to get married, and in that period of time, they obviously experience domestic violence, and the marriage is utilized as another tactic, obviously, for control and abuse. And so that's pretty important. Another recommendation that the Australian Law Reform Commission made is that there be a new model for non-judicial determined claims of family violence. Under the proposed new model, applicants can submit any evidence in making valid non-judicial determinant claims of family violence, in addition to the statutory declaration for competent persons. So, as well as this, the Australian Law Reform Commission recommends that the repeal of the legislation governing prescriptive forms of statutory declaration. So that means the repeal of Regulation 1.26. And that these amendments be reflected in the Department's policy guidelines. And that the recommendation, the current process for referral to an independent expert, though, would remain available where a decision maker is not satisfied on the evidence that an applicant has suffered domestic violence or family violence. Such a change in the evidence requirement will mean that an applicant client will no longer hinge on whether or not she can access competent persons. It would also allow victims to provide more authentic, less contrived evidence. So it is recognized that many victims might be seeking assistance from other persons, such as bilingual workers or English as a second language teachers. They hear a lot about experiences of violence and they can't do anything about it. So this recommended model essentially recognizes that there are people beyond prescribed list of competent persons who are capable of providing evidence in support of a person's family violence claim. At the Refugee and Immigration Legal Service, we endorse the recommendation in this regard because we believe that it aims at improving the simplicity of the system rather than making it more burdensome and complex. Whereas we also supported the retention of the provision of the expert endorse the recommendation that the prescriptive requirements of the stat and the expert removed. And what we said in our submission was that we really believe that we should maintain the competent persons, and that really we don't really like the independent expert. So in our experience, the scheme in its current form often requires a victim to go to a prescribed competent person, obviously, and create a relationship with them. So it's pretty. It doesn't. The evidence doesn't come in a natural manner where the victim has sought help. They've gone to the English classes, for example, and they talk to the teacher about it because they're the only person they have to talk to. So that's not, in this recommendation that could be utilized as evidence. Sorry, I'm rushing it now. The Australian Reform Commission is that the totality of the evidence provided by a victim should be considered taking into account the circumstances of the individual. So this will require a weighing up of the evidence and an assessment of the applicant's credibility, a task not uncommon for decision makers in the immigration context. That's a problem. So there are other recommendations there that are important. I'm not going to go through them because it's too much. But basically, there has been a recommendation that there is increased access to emergency accommodation and income support. And some of the people who work in women's refuges here will be glad about that because it means that people might have access to income support and we won't have those women without income any longer. That is if the Minister actually accepts those recommendations, of course. And that a new visa subclass for second applicants on temporary visas who are subjected to family violence be included, I suppose. I would say that's pretty controversial because it means simply that somebody who is here on a temporary visa, not necessarily applying for a permanent visa, can apply for a particular type of visa that would allow them to stay in Australia until they can make arrangements for living or arrangements for what they're going to do, or even considering to apply for a permanent visa in their own right. So it's giving them time to sort out that, to seek support, and not to have to leave Australia immediately. I'm not sure whether that's going to be accepted or not. And the Australian Law Reform Commission, in looking at that, cited similar legislation in Canada where a person on a temporary visa can still apply for permanent residence on humanitarian and compassionate grounds if he or she has experienced family violence. Obviously, the Australian Law Reform Commission also has identified the risk that such a visa might create incentive to claim family violence as a means of securing a migration outcome, and obviously, that would be an issue that I'm sure our Minister and the delegates will look at. Okay, okay. I'm going to jump that, and I'll go to the independent expert. The Australian Reform Commission also raised well, a lot of agencies raised this issue with the Australian Law Reform Commission, and that is the fact that immigration officers refer people to the independent expert. And some of the issues that were raised is that that process lacks transparency and it doesn't comply with the basic rules of procedural fairness, in that the officer does not give reasons for referring the matter. In our experience at the Refugee and Immigration Legal Service, applicants sometimes appear to be referred unnecessarily. Other agencies report that the referral seems to happen as a matter of routine, so when they receive competent persons stat decks, they refer to the independent expert. We submitted to the Australian Law Reform Commission that the quality of the process and assessment by the independent experts varies greatly from expert to expert. And so there's very little consistency in their approach. One of the things, and I probably have to finish up soon, but one of the things that we found in the last 2 weeks, we've been going to Centrelink appointments ourselves, what we found is that they're starting to utilize the typologies. So some of the decisions have been based on, situational domestic violence or, spouse or whatever. And so that's a big issue. That means that the Centrelink social workers are being directed to actually, look at that framework as a decision, making capacity. And it's problematic because they have the final say. And it's, yeah. So the other issue identified, obviously, the finality. The finality of the independent expert opinion is a very important issue. I'm going to finish because I think here that it is stressed out. But I do want to tell you about one case that I think you need to look at if you're working with, if you are actually doing competent person stat decks. And one is the full federal court decision on MAMAM, M-A-M-A-M, versus the Minister for Immigration. So they talked about the procedural fairness of the minister's delegate. And that was basically because the independent expert made a decision based on a letter that the department had received from the person who alleged domestic violence partner, and made decisions based on that letter, but didn't provide the evidence or the information to the applicant for respondents. So not procedural fairness was afforded in that case. So it's an interesting decision to look at, I think, because I'm not quite sure how they're going to deal with it. And basically the summary of the recommendations, I think most of you probably talked about that, but there's some of these summary of the recommendations that the Australian Law Reform Commission have made with regards to immigration. And the last thing I want to talk about is the changes that are coming, because the Minister has already issued a press release on the 17th of June, where him and the Minister for the Status of Women, Julie Collins, announced that they will be introducing amendments designed in the view to improve the assessment of family violence in migration law. So that's really important. You need to really keep an eye on this. The amendments include the provision of a wider range of evidence to support claims of violence as recommended by the Australian Law Reform Commission. Not quite sure that they're going to go that all of that way, but certainly some things. So Minister Bowen acknowledged that the current process of obtaining stat decks which with a set of technical requirements can be difficult for some victims, and that it is both fair and sensible to allow victims to provide other forms of evidence where they exist. So the implementations of the amendments is scheduled for the 24th of November 2002. In the interim, the Department of Immigration will update policy guidelines to confirm that any evidence provided by the applicant in addition to the stat decks required under the existing legislation should be considered. So between now and 24th of November, we have to do the competent person stat deck plus any additional evidence that we can get our hands on. Of course, that would be very useful. The Minister stated, though, that to ensure the integrity of assessment, applicants will need to provide a minimum standard of evidence. To know exactly what the regime will involve, we'll have to wait and see, because the devil we know is in detail. So there's nothing to suggest that the Minister will implement any of the other recommendations of the Australian Law Reform Commission. Minister wrote to a number of agencies and is obviously asking their opinions about the amendments. It appears that the possible amendments will include the replacement of the current system of 2 stat decks from competent persons with a requirement that an applicant present a minimum number of documents from a list of acceptable forms of evidence such as this. We can see lots of problems with it, but anyway, we put that down. And the problems that we see with it is that basically what's going to happen with this is that again the GIAC officer will make an assessment whether these things are acceptable forms of evidence or not, or whether this evidence tells them enough to believe that the victim had experienced domestic violence. I suppose we are pretty negative and we think that they're probably all going to be sent to the independent expert, and probably that's what's going to happen. But we have to raise issues around the finality of the independent expert, obviously. So people need to be getting those, trying to get those letters. And so, okay, thank you.
Would anybody like to start with a question or comment? No, Rachel, go.
Thank you, ladies, for today. It's been extremely informative, and I would have loved to have heard a lot more from you, given time. For Heather Douglas, I know that you touched on the guidelines available for magistrates, and again, I guess this is always a concern that no matter what legislation you have, it's the application of that legislation. So do you know about any training packages that are going to happen, professional development training for magistrates? Is there anything mandatory for them, or is it just here's bits and pieces?
There is training, and yeah.
I can actually answer that.
Actually, we did the microphone here.
Yeah.
I think I can say that the only state conference
You can't hear.
You have to. They have received...
This very morning, I think, or yesterday morning, there was a session.
Yeah, that's right. Heather spoke at the conference on an entirely different subject. So she knows that the session was on.
Yeah.
And yes, there has been a session on domestic violence, and that was attended by magistrates and judicial registrars. I understand there's been a concern about judicial registrars attending, and they were certainly invited to attend as well. Sorry. So that's all I wanted to say about that.
Yeah, so they have a regular conference every year where they put sort of key issues that are arising on their agenda, but they also have ongoing education. And the current Chief Magistrate is really interested in domestic violence and responses to domestic violence. So I think he is very responsive to anything that should be distributed to magistrates, and so I mean I think they can respond to people who have things to offer. Magistrates, Brendan Butler I think would be willing to distribute them. I don't think that he would not do that. So, but they do have the once a year kind of core conference where everyone comes together.
Is it mandatory though, or is it still elective to attend that conference? So they're still missing out on different magistrates?
Well, I'm sure if they're sick, they don't go, or there were people missing the other day, but I think it's effectively required that there's attendance at that conference. I'm not actually sure, it was a panel discussion on domestic violence yesterday morning. I'm not actually sure exactly what was covered, but it was about the new domestic violence legislation and how that would be dealt with in the courts and the issues that it might raise.
Yeah, I've enjoyed that this morning. I would have liked a bit more Indigenous content, especially as I've been asked to comment on it, and I'm not right up to date on the legislation. But my comment is, because I come from a small community, and the police are always taking the women and the children out of the home, how do we get our local police to enforce the ouster order? You know, and take the partners away.
How do we do that? Yeah, how do we do that? I mean, I think that...
pretend it's on.
I don't know.
I don't think so.
You've got to hold it close.
I don't really know the answer to that. There's been research on this for years about ouster orders. There's a lot of discomfort with ouster orders, especially where, and this might not be such an issue in Indigenous communities where maybe everybody's on the public housing agreement, but there has been lots of concerns of ejecting perpetrators from houses where they have co-ownership,
And I guess the legislation is trying to say in that context, even though someone is the co-tenant and it's listed on a lease or whatever, that doesn't give them any extra right to stay there. They could still be the subject of an ouster order. So there's kind of clear legislative provisions now which kind of try to say that even in those contexts where this is your home and this is a place where you have a lease, you can still be ousted from that house. So there is that. But there is also a problem in the, well, not a problem in the legislation, it's inevitable that this should be here. The police also have to consider the accommodation offers options for men as well, or the, not men, the perpetrator who's told they have to stay away from the house overnight or for whatever period. So that brings up this issue of the shelter movement, which has traditionally been available to women, arguably, and what kind of accommodation options exist for men. So I'm not sure what kind of social responses there have been in that direction, because I think it might be the case that police might be continuing to be unwilling to oust men from homes where they have nowhere to go. So I think that is potentially a problem.
Can I just ask clarification? I thought you were asking about how do you get the police to enforce an order, an ouster order that's already in place. Was that your question?
No, not in place, but just to get them go and cool off somewhere, because we're talking about women with 6 and 7 children have to move. They've got no clothes, no food, nothing. You're sitting comfortable at home, and they're stressed right out at our service.
Can I just say, I hope you had an opportunity to pick up a copy of the Family Law Council report that was on the table in relation, okay. I brought both of those reports, the Aboriginal and Torres Strait Islander report and the culturally and linguistically diverse clients report. They're reports that have just been relatively recently released by Family Law Council, where we have looked at the issues confronting people in those groups in using the family law system. So I hope you've all had an opportunity to perhaps pick one up, otherwise they're available on our website.
But I think the issue of implementation of the legislation has been an issue around for many years. We know that. I mean, that I suppose what to do is a very big question, because really what should happen is that the police must implement legislation. They are an important aspect of the implementation of legislation. So what can we do? I suppose as advocates and support workers, we probably should be able to try to use whatever is available. Not that many things would be available now in terms of consultative mechanisms and making sure that we put those complaints regularly to the bodies that should receive those complaints, and making sure that we as advocates are very active. And I know that the women's sector and the Aboriginal women's sector particularly has been extremely active, but I think that it has to continue to be the case, because we know that historically it's quite difficult to get police to implement any type of legislation pretty much that it affects women, I say.
Can I just mention something too? What's really disturbing in relation to your response is that the Griffith University Criminology Department have just, which you heard, Heather, that research about police engagement with domestic violence issues. And there was a report done in 2005 by the Crime and Misconduct Commission of police engagement with domestic violence, their attitudes towards domestic violence cases and call-outs. And research conducted in the last year by Department of Criminology at Griffith, which was presented a few weeks ago at a symposium Heather and I were at, suggests that police are becoming less interested in domestic violence. It's getting worse, that response. So I guess that does underline your concern and the need for training and consistent and actually repetitive training. Getting out there over and over again to give the same old messages, unfortunately. And in fact, when I was at the Magistrates' Conference, they pointed to the fact that there is turnover in these organisations and it's relatively regular. So you do need to be constantly reporting and repeating the messages. So yes, the training issue is really important across the board.
And the accountability, as Raquel's saying, then the complaints procedures.
I mean, it's good to get get your hands on the operational manual of the police, and so then you you just quote it, you just sort of use it for the benefit of, obviously, of your clients.
Oh, I'm just going to say that the words are really big. I'm not too confident in reading and understanding, you know. English is my second language, you know, because I taught Aboriginal English. So if it was simple, yeah.
Yeah, no.
To read.
I can relate.
I've got a question if I can. I don't want to jump in on the audience if they have something, but I've got a question, one for Heather Douglas and one for Zoe. Well, I suppose I'd like you to expand on a couple of points you made. Heather, you were talking about the, you know, the needs, the levels of evidence and the range of evidence, you know, some of the barriers to actually being able to use criminal law. What difference do you think that the inclusion in the Domestic Violence Act will make, or can it make any difference, really, by having that particular reference in the principles that the criminal law should be used in conjunction with the civil law? Is it just a motherhood statement?
I think it's a motherhood statement. I just think it's a motherhood statement. I think that that's you know, that's what the Beyond These Walls said as well, that old report that introduced domestic violence legislation. It was never meant to be a standalone piece of legislation as the single response to domestic violence. Look, it's good to have it stated in the legislation that this is the situation. I mean, it's helpful for new people coming into the DV sector that these two things can go together. I mean, as I said, there's even workers at the Caxton Legal Service who say, why is it that, you know, if you've got a DV situation, you go to this system and they don't have anything to do with the criminal justice system? So obviously even people working in legal centres aren't completely clear that these two systems can operate together. And when I ran a DV course at in the law school at Griffith a few years ago, this has always been my worry that the DV legislation has just trumped the criminal justice process, and I think largely it has. And in many situations that isn't a problem for individual women. They don't want to get involved with the criminal justice system, but when many women do, and they're finding themselves only getting access for one reason or another to the DV legislation. So I do think it is a continuing problem, and I don't know that the legislation goes particularly far. The trouble too with the domestic violence legislation is that that protects victims, and the interest in terms of criminal procedures around criminal justice are about innocent until proven guilty, beyond reasonable doubt. So it is a system that does have high thresholds for proving criminal justice issues. So, and there's good reasons for that. So there is this disconnect.
Yeah. That's not your question to me, is it?
No.
Did you want this?
Unless you want it.
That's fine. Yes.
What I'd really like you to expand on, really, Zoe, is the point that you finished on about the exclusion, the definitions that have an effect of exclusion, and then the family law provisions that have an effect of inclusion. And given that I suppose one of the potential benefits of the typologies, and I suppose the aim really is to try to better distinguish between, men's violence, women's violence against men and men's violence. I mean, that's really how it's come about. So how do we do that then? What do we, can you talk a bit more about the exclusionary, to talk a bit more about the exclusionary effect and the inclusionary effect and what that might mean, and maybe together we can have a discussion, figure out, well, what do we do about that? How do we do it if the typologies are problematic?
Okay. Easy. Look, my point there was really, and this was something I really started to think about when I was analysing the presumption itself, and when the 2006 legislation came in, or when they made the 2006 amendments to the Family Law Act, and I'm sure that many of you in this room are very familiar with that, but the key centre of that is the presumption that it is in the best interests of children for their parents to have equal shared parental responsibility. And the thing that made that new change to the law, I think, particularly dangerous in some families, was then the fact that the provisions about time got tied to that. So although the law wasn't that equal time was in children's best interests, once an order is made for equal shared parental responsibility, judges are required to look at making orders for equal time. So you actually bring the physical arrangements for that family then come into play. It's not just an idea about who's exercising parental responsibility, but actually where the kids are going to be, and that whole physical regime that they're involved in comes into play. And when I looked at the way that because you know, in the original report from the committee that was set up for the 2006 amendments back in 2003, and that report that many of you would know, that Every Picture Tells a Story report, they suggested that that presumption be there, but then they suggested that there be a presumption against such an order being made where there was family violence. But that's not what they did. They didn't make the presumption against. They left the presumption for, and then they made family violence a basis to exclude. And the more that I read the way that the judges were actually deciding the cases, and as the data started to emerge from the AFES evaluation and other evaluations, one started to see that that exception just didn't get used. And the same thing happened with the family dispute resolution. And look, lots of services made submissions to the government about the fact that people would not self-exclude. People would actually put themselves in, so people would go. Many groups said to the government, you will have hundreds of people at family dispute resolution who've experienced family violence. That is going to be what happens. And they said, no, 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 it won't. And of course it did. I mean, you might as well, there was no point setting it up if you weren't going to let in people who'd had family violence, because that's so many of the people who separate. That's why they separate. That's the thing they don't seem to get. People separate because things are going wrong in their relationship, not because it's going right. But so what you then do is you develop this system whereby once you've got a presumption like that, what the big message that the law is giving out is everybody's in this first until we start to exclude people. So it becomes a very, very powerful legislative device, because for everyone who comes into the court, you start by assuming that that order will be made, and you only don't make it if certain things get proved. And if they never get put up strongly, and people frequently come into the court saying they're going to consent to that aspect of things anyway. And as soon as they've consented, you've got your prerequisite to look at the time provisions. On the other hand, what worries me then, if I turn all that on its head, and I look at this, you know, because what I see is these words that have come in through the social science literature about these different typologies. And they really hit the scene in Australia in 2007 when that benchmark report was done by AFES looking at what was going on in terms of family violence before the amendments came in. So although it was done just after the amendments, or was published just after the amendments, it looked back at everything before. It was a benchmarking report to go, well, what's happening before the amendments so we can evaluate change that might occur. But they then started to talk about these different typologies using a group of researchers from America who talk about this stuff. And there's Michael Johnson, Janet Johnston, Joan Kelly, there's a group. And it's actually, in terms of the world, this is a tiny group of social scientists, but they're very influential, very influential. But if you read the literature from the UK, you don't find this discussion coming there yet. It's not infiltrated their legislation, or in the UK they still talk about different types of family violence. In the UK are sexual violence, verbal abuse, all those examples that are listed in our legislation. They don't use that typology idea. We've somehow embraced it here in Australia. And look, it is very useful to distinguish, in a way, different kinds of violence. We know that. Not all domestic violence is the same. But what tends to happen is that the coercive and controlling violence in the social science literature is the serious family violence. And then there's these other, depending on whose literature you're reading, 3 or 4 kinds of family violence, all of which are they're not serious family violence. Now, and you know, it doesn't mean that they're not relevant to decision making, it doesn't mean that they're excluded. But for social scientists, they use this to decide what kind of intervention, social science intervention, to be providing to their clients. Once you give lawyers a set of categories, we use them to include or exclude. You know, I mean, lawyers are used to doing it. That's how legislation is set up. I mean, and it's a famous kind of example, not very exciting, but, you know, there's a lot of technical issue in the law about whether something is a lease or a licence. And there's textbooks written about this. The lawyers categorise, it's either a this or a that. And if it, you know, like if it looks like a rose and smells like a rose, it's a rose. So I mean, once you say to lawyers, okay, there's 4 kinds of family violence and one of them is this kind, then the rest is something else. And this is what worries me, that I think that I actually think that language of coercive and controlling violence has found its way into into the Family Law Act and into the DV Act, not through the social science literature, but through the long held attempts, or the long put in place attempts by women's groups to explain what is domestic violence, what makes domestic violence and not something else. And so those words, coercive and controlling, have been used by women's groups exactly to pick up on that thing that domestic violence is a pattern, that it's something that occurs over a period of time. And the point that Heather made about the way the criminal law looks at discrete things and the difficulty about that with the kind of pattern of abuse that often occurs. So what I'm saying is these words, coercive and controlling, have been used by 2 different groups to achieve 2 different purposes. They've been used by women's advocates to describe something very deep about what is domestic violence. They're used by some social scientists to create one category out of a number of categories. And what worries me is that people don't really get that difference, and that it is the typologies literature that's become suddenly really well known in Australia. And police get told about it, magistrates get told about it, every family court judge has gone to training about it, immigration officials get told. I mean, what's Raquel saying this morning? What's her name? Competent persons are using those typologies to describe what's happening now in migration matters. Police get to, police are going to be, going to domestic violence situations and trying to work out whether what they're being told about is common couple violence or coercive controlling violence. You read family court judgments, and this is the latest thing that I've written about, where we see how many family court judges use this language to decide what. So they quote the literature. The judges, quote the social science articles in the courtroom at the time of delivering judgment. Nobody's had a chance to make a submission on it. Nobody knows it's coming. None of the parties use it in their submissions and in their evidence. Their evidence is, he hit me, he pulled my hair, he punched me in the face, he did this, he did that. Then the what do they call? Federal magistrate or the judge, when they're delivering judgment, goes, I'm going to refer to 3 articles here in my decision. The article of Michael Johnson and Joan Kelly, the article blah, 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 blah. These articles tell me there are 4 kinds of family violence. This judge, I say that the kind of family violence that's happened in this case is whatever. And this is exclusionary, not in, so where the presumption is inclusionary, everyone's in unless they're out. This is exclusionary. Unless you're this kind, you're not in. So I think those kinds of tug of wars, I think, are going to be very dangerous for some families that are going to end up excluded from family violence and included into the presumption.
So is the domestic violence legislation preferable then in the way?
I mean, I actually wonder if it was. I actually think that maybe in the end that the Queensland domestic violence legislation might turn out to work better in practice than the family. So that's my point. So the Family Law Act, the way that that's happened is that making that coercive and controlling, and look, women's groups supported it. I think, I can't remember what I actually said. I actually think that idea about coercive and controlling violence is a really important one to understand. And if we could all just think it was going to be used exactly the right way, but the problem is that we know, what Raquel was saying, in implementation, there's always problems in implementation, and there's always misunderstandings. And the training that everyone has been getting is about the typologies. That training has gone all around Australia to almost everyone involved in the family law system and the domestic violence sector. Maybe not all the people on the ground always, but all of the people who are the decision makers. in that area have been trained to know these typologies.
I just want to kind of develop Zoe's theme further. She has very, very articulately highlighted the deficiencies and the problems in these notions of typologies. There is a very significant debate occurring among academics, decision makers, policy makers about this. There is certainly an awareness at many levels of the dangers and the difficulties of typologies, and we are starting to see a very overt discourse about this through the work of people like Jane Wangman. I can also say that the family court's best practice principles in the area of family violence are currently being reviewed. There is a set of best practice principles that actually do kind of refer to things in a way that might be construed as consistent with the typology idea, but I am aware that there is certainly an awareness at those levels, and the notion of these typologies is certainly not universally accepted at the level of the high level of policy and practice that is going into rethinking those best practice guidelines. And basically I think this is a debate that is really starting to gather pace, and the more that people can get in with it and engage with it and problematise the literature on typologies and problematise the implications for practice that those typologies have, the stronger position that we'll be in. And I should just say I wasn't part of the report in the 2007 one. I actually did the work that led to that report, and my work did not support any engagement with typology. So there we go.
Can I say for those, I mean, I know that you don't all have access easily to articles, but Jane Wangman wrote a very good piece for the domestic, what's it called? The Australian Domestic Violence Clearinghouse.
Yes.
Was it last year it was published? So that's just accessible on the on their website as a issues paper, I think. Yeah. And she sets out some of these problems that we've been talking about, but doesn't necessarily put it into the context. But yes, I think those best practice principles that we've got in family law at the moment are highly problematic because of their use of the typologies. Even though in theory they're very useful, there's some real difficulties, and because the whole reason they're reviewing it is to bring them into line with the new definitions. So I'm concerned that if they go anyway, they might go towards accentuating those issues. But let's hope there's some people in important places who've got another view. Right.
Thanks, Zoe, and thanks, Heather, for your expansion on the points. Les, there's a couple of people in the audience now who...
Mine might be quick. The Queensland legislation since 2003 has had broader relationships, including family relationships. So women over the age of 60, they're quite overrepresented in protection orders and violence. They call it elder abuse sort of thing. And in those older categories, it's usually under the family relationship category, not under the spousal relationship. We haven't really heard about how are older women being protected under the new legislation, not so much under the Family Law Act. Of course, that's families breaking down, but under the Domestic and Family Violence Protection Act in Queensland. So has anyone got any comments about how that is going to increase protection for older women?
You might be the best to talk about that. I haven't looked into the elder abuse issue.
I don't think that there's any provision specifically in the new legislation that relates, directly talks directly about older women or old people. I just think it's by the inclusion of the preamble and the principles and the object makes it a better piece of legislation for everyone, which would include older women. But I'm not aware, I can't recall any specific provision in the new legislation that would address that, you know, your question there.
It is interesting though, because I remember going to debates about the new legislation, and there was lots of discussion about younger women, dating relationships and things, but I don't remember that being raised. So that's, yeah, it's an interesting point, but I can't point to any clear provisions.
Maybe an area because
yeah.
you know, older women are still being
Exactly.
used, but in a different way,
Yes.
which is what this
Yeah.
conversation
Yes, yeah. I mean, we did have a particular agenda for today, obviously, and that, I mean, it's interesting also, the ladies have gone from the back there now, but I mean, there's very little in either of the new acts that in any way particularly highlight issues around Indigenous families, which doesn't mean that they may not play out to either be good or bad. But in terms of the brief today, one did not find oneself looking at that issue because it wasn't a subject of change in particular, which unfortunately isn't because everything's going so well. It just didn't. It's really not part of what
having
was
said
looked at.
that, sorry Zoe,
Oh, I was just going to say about the higher levels of criminal justice system, there was engagement with the ALRC report on that in terms of spousal killings and issues in the Supreme Court trials. Indigenous women were a particular focus. But
I'm just thinking about in terms of cross orders and the fact that police are mostly made, even though it's not directed particularly at Indigenous women,
That's where it's played out so
that's where
seriously.
it's played out, you know, in terms of the police applications in particular. And I think that so addressing that is a particular benefit to Indigenous communities.
Absolutely.
Anybody else?
I'm just wondering about now I've forgotten the name of the person, the competent person information. So with the increase in acknowledgement of the of children's rights to be safe within their families, is there a requirement for any of those competent persons to have, as part of their qualifications and their background and experience, specialties in understanding children?
Not necessarily, because they're making an assessment about, well, I suppose in a way yes and no. Depends. They're making an assessment about whether the woman experienced domestic violence or not.
Yes.
And if the woman has a child, they should really then look at whether the child has experienced domestic violence or not. But that's about it. I mean,
so
a specialist background on children's behaviour or whatever, not really. I mean, social workers might.
So how
psychologists
do we then
might
get the experience of the children?
The children would not be. The children would not be interviewed, if you like, or
so
would not be.
through the mother.
It's through the mother, yeah. Unless the way that you can get that for inclusion of the child is you might be able to get a statutory declaration or a stat dec from, say, the state child safety, child protection officers. You know, people like that. Yeah.
And I mean that you've raised such an interesting question because in the whole area of family law now, that whole question of children's participation in a range of ways is another area of deep exploration, and that kind of again. I mean, look. Although I'm critical of the things that have happened in some ways, I don't pretend that there are easy answers or that I've got the answers either. I'm sure that anything that I would suggest, if you put it in place, the problems will then immediately emerge. It's so difficult. And this area of children's participation is so vexed as well. The kind of great concern about making children be the ones that actually carry the message and the risks around that, and yet their exclusion, without doubt, leaving children feeling entirely disenfranchised and having all kinds of long-term implications. But so finding the safe way, whether it's about these kinds of issues or whether it's right there in the courtroom, and of course the decision that will be coming down from the High Court in relation to the Italian situation, the central issue, one of the central issues that's being legally put forward there is that these children should have had a different kind of right of representation in those proceedings. So that question is going to be very interesting to see what the High Court says about that, because as far as I know, it's the first time that the High Court has looked at this particular issue, but it's in such a specific area of family law. So we might find that whatever they decide will be considered to be limited to cases of international child removal as opposed to more generally applicable. But there'll be an argument to say that it's applicable to cases involving family violence, because that's one of the issues in that case as well.
However, though, I think in the interim, between now and November the 24th, there evidence that actually, you know, that women can present around the effects on children can be produced, can be utilised. So the competent person is one person who would make an assessment about that. So you can have perhaps say a stat rec from the school counsellor or, you know, somebody like that. Or, yeah, but it's not prescriptive, that it's not prescribed that they have to, you know, have that kind of background.
I think we've got time. We're actually over time, but the last one.
Just one comment. While I was listening to the presentation by Professor Heather Douglas, I was concerned that there might have been an incorrect inference that police protection notices that are issued then don't need to go to court.
Yeah, 28 days, so they've got to go to court within 28 days.
So I think that just needed clarification. That there's still that court process attached to them.
Yeah, that's right.
Well, in fact, a police issued notice acts as an application for a protection order. Yeah. So thanks for clarifying.
Yeah, but as police will be aware, often these fall out too, so they might, a lot of them won't end up being litigated, presumably. We'll see.
Rachel's desperate for a question, and then I will have just a couple of closing comments before we leave.
Just one last quick one on the police. I noticed there was an exception slide there about the police not holding the perpetrator, and I know in certain cases
they have powers to do that under new legislation.
While they do that
but they can only get a police protection order in situations where holding the person is not appropriate, holding the person in custody is not appropriate. That's the situation under the new legislation. So that's still available, but another option for police is a protection order, a police issued protection order.
So what's the difference between the interim order they do now to take it to court within 3 days or whatever, to the new one that they're doing in this order to court anyway?
It's an immediate.
I think it's a very good question.
It's an immediate.
I think there's a good question about what's the difference between the new police orders also and the old system of releasing someone on conditions. I mean, really, this is a more dressed up version of that. And I think, again, it becomes that philosophical stuff, or that by having spelt this out differently now and given it a different meaning and wording, it could well be a positive thing. But I think there's a range of issues, and if you actually look at it, it's not very different to what used to be. It's just got different clothes on now in some ways.
There's a clear breach provision now, with a fairly serious penalty attached to it.
Yeah.
So I think that makes a bit of a difference, and that might...
Really the only difference is a release from custody order lasts 7 days and your police protection notices will last 28 days.
Presumably most of them won't last that long though. They'll be coming to court much more quickly.
But that's the difference really, because they're both binding.
Yeah.
But they're cultural change things, aren't they? I mean, they have some really good things that and look in both the acts for everything that is wrong and that we can critique. There are cultural change ideas, I think, underlying the changes and in the migration provisions as well, or the forthcoming ones. You can see cultural change that borrows from all the reports and things that have been going on. But you know, what'll happen? What'll happen?
So finally, I just want to thank the 4 women who you have before you who have shared their time and have been very generous with the presentation, the preparation, the delivery of those presentations. And I found it a really wonderful experience today. I've learned a lot, and I think that everybody here has. And it just reminded me of talking about what I've learned, and I'm sure that others have learned as well. And thank you all for your time in being here today. Thank you.